I trust that you guys already watched our introductory lesson yesterday. Persons and family relations is divided into two parts. First is the persons, which covers the first part of the civil code, and family relations, which in turn is covered by the family code. Persons, along with obligations and contracts, are the two civil law subjects covered in your first year in law school. They are offered first precisely because they lay down the foundation of civil law. And once you know persons together with obligations and contracts, you will have an excellent working knowledge for civil law subjects such as sales and lease, transportation, mga public utilities laws, torts and damages, credit transactions, among others. Now, I have been lucky to be under Dean Almase and Attorney Joselito Alo in most of my civil law subjects when I was still in law school. So allow me to share with you what I have learned from them and in the past years as a professor of persons and family relations. Again, the study of persons and family relations starts out with the new civil code. While persons and family relations main text refers to marriage and its consequences, there are also other issues that are sources of bar exams questions. And I learned from Dean Almase that the preliminary title, which is actually divided into two chapters, will help you see through the law as it introduces you to the world of so many laws. The chapter on effects and applications of the law will help you understand the law because instead of just defining the law, it actually states, or this chapter actually states, the effects and its application. And this best exemplifies the maxim, jure lex, sed lex, or the law may be harsh, but it is still the law. The chapter on human relations on one hand would tell us that the law should be interpreted not on the letter but on its spirit. Kanaingon nato nga, the law should not be interpreted by the words that killeth but by the spirit that giveth life. The spirit in this case is that which is idealized in the sense of justice. So basically, these are the concepts that you will see manifesting in some provisions of the law and also in the decisions of the Supreme Court. So let's start. Article 1 provides that this act shall be known as the Civil Code of the Philippines. So I think this doesn't have to be explained because this only tells us the name or the title of the code, which is the Civil Code of the Philippines. Now we go to Article 2. This actually says that laws shall take effect after 15 days. After 15 days following the completion of their publication either in the official gazette or in a newspaper of general circulation unless it is otherwise provided. We will focus on this particular provision this evening, no? And I'd like to approach this by answering the questions what, why, when, how, where, so on and so forth. So we will read this law by considering how will this dictate or affect the applications of law. Okay? So let's start first with what aspect of effectivity. When you say aspect of effectivity, this actually talks about the effectivity of laws from the viewpoint of publication. Now, why is there a need for publication? This is in order to satisfy the due process requirement. Now, another question. What laws? The term laws, what does it mean? Does this cover all the laws? Ningon ang Tanyada versus Toviera, this means generally all laws, not only those of general application, but all laws, okay? Except, of course, those that are of interpretative character, such as interpretative regulations, mga internal rules, or instructions. Now, the next question would be, how is this published man? Pwede ba nga the title lang of the law? Pwede bang a piecemeal of the law, a part of the law? Niingon ang balaod or niingon ang Supreme Court, everything must be published, okay? It must be published completely. Now, the next question, where? Where do we publish it? It is either in the official gazette or in a newspaper of general circulation. Now, we go on to the very point of this provision, which is answering the question, when does it take effect? Okay? Article 2 would provide that laws shall take effect after 15 days following the publication. So the rule that laws must be published before they can become effective was actually laid down by the Supreme Court in the case of Tañada versus Toviera. What happened here is this. Sometime in 1980s, Tañada with a group of lawyers actually came to court and claimed that they have a list of presidential decrees issued by former President Marcos. And according to them, these presidential decrees were not published. And invoking the right of the people to be informed on matters of public concern, as well as the principle that laws to be valid and enforceable must be published in the official gazette, Tañada and his group actually filed for a case to compel the public officials concerned to publish or cause to publish various presidential decrees, mga letters of instructions, general orders, proclamations, executive orders, letters of implementation, and administrative orders issued by the then President Marcos. The Solicitor General in this case, representing the government and its officials, moved for the dismissal of the case, contending that Tañada and his fellow lawyers have no legal personality to bring the instant case. Okay, but we will not dwell on the legal personality. Let's just focus on the second issue or the main issue that Tañada or the Solgen actually raised in this case. The Solgen basically said that Article 2 provides that unless it is otherwise provided, then it should not be declared invalid because the law provides for the phrase unless it is otherwise provided. So how did the Supreme Court decide on this case? Let's see. So the Supreme Court said the publication of all presidential issuances of a public nature or of general applicability is mandated by law. Obviously, presidential decrees that provide for fines, forfeitures, or penalties for their violation or otherwise impose a burden to the people, such as tax and revenue measures, fall within this category. Other presidential issuances which apply only to particular persons or class of persons, such as administrative and executive orders, need not be published on the assumption that they have been circularized to all concerned individuals. The provision or the publication of presidential issuances of public nature or of general applicability is a requirement of due process. It is a rule of law that before a person may be bound by law, he must first be officially and specifically informed of its contents. Remember this that the case of Tañada versus Toviera said that the clause unless it is otherwise provided refers to the date of effectivity and not the publication requirement, which cannot and will not in any event be omitted. This clause does not mean that the legislator may make the law effective immediately upon approval or on any other date without its previous publication. The court said and declared that presidential issuances of general application in this case, which have not been published, have no force and effect. So the question now is this: when do laws become effective? So there are three ways to answer this. First, whenever the law provides. Second, if no effectivity is provided, then it should be after 15 days following the publication. And then if it provides that it shall become effective immediately, it shall mean that it shall be effective upon publication. Okay? Tagsa-tagsaon ni nato. Now, what do we mean when we say whenever the law so provides? Now, an example, Ani, would be this, okay? A law is passed that actually imposes a tax on individuals with uyab, okay? Double the amount to the tax paid by single individuals, okay? And then the law provides that it shall become effective on October 5, 2020. So, if the President approves it and signs it into law, let's say in September 23, in October 5, 2020, it becomes effective. Okay? Because the law so provides. Mo na siya pasabot anang first instance. And of course, we should not forget that it has to be published. Okay? The requirement of publication must not be omitted and must not be dispensed with, even if the law specifically provides for the date of effectivity. Now, what if there's no effectivity clause? What if there is nothing in the law that actually provides for the date of its effectivity? Now, we go to Article 2, which actually provides that laws shall take effect after 15 days following the publication or following the completion of its publication. An example, Ani, would be this. A law that imposes a tax on individuals with uyab double the amount to the taxes or to the tax paid by those who are single. And it was signed by the President, let's say on September 23, 2020, and published on September 24, 2020. The law has no effectivity clause, so it becomes effective on October 9, 2020, that is 15 days or after 15 days following the completion of its publication or on the 16th day of publication. I hope that's clear. Now, what if the law would say it shall take effect immediately upon approval? What does this mean? So, this actually means that this is actually settled in the case of Labugal Balaan Tribal Association Incorporated, wherein the Supreme Court would tell us that when the law says effective immediately upon approval, it becomes effective immediately upon the publication. The Supreme Court further said that what is mandatory and what due process requires is that the law must first be published in either the official gazette or in a newspaper of general circulation. We are now in Article 3 of the new Civil Code, which provides that ignorance of the law excuses no one from compliance therewith. This is actually more popularly known as the Latin maxim, ignorantia lihes non excusat. We talked about the publication requirement last time, and we said that it is required to satisfy the due process requirement. Bakit ba? Nga naman, why? Kasi when the law is published and becomes effective, it is conclusively presumed that everyone knows about it and is bound to obey it. Now the question is, what is the extent of applicability of the maxim? It actually extends, ladies and gentlemen, to all kinds of domestic laws, whether civil or penal, whether substantive or remedial. Now when we say civil, this is actually a branch of law that generally treats of the personal and family relations of an individual, his property and successional rights, and the effects of his obligations. Ang example, ani, kaning atong subject. When we say penal, this is that branch of law that defines crimes, treats of their nature, and provides of its penalties. Substantive, on one hand, is that which establishes rights and duties. Remedial is that which prescribes the manner of enforcing legal rights and claim. Again, the maxim on ignorance of the law will only be applicable to our laws, okay, to our domestic laws, which means that ignorance of foreign laws is not ignorance of law, but mere ignorance of fact, and must be alleged and proved. So, kailangan pag nag-raise ka ng foreign law, kailangan mong i-allege muna at i-prove para tanggapin ng ating courts as a matter of fact. Okay? Yung example lang naman ito, yung marriage celebrated in China before a village leader doon sa China. Now, itong marriage nito cannot be recognized as valid here in the Philippines unless magpapakita ka ng proof that indeed in China and according to Chinese law, itong marriage na ito is regarded as valid. Without such proof, we will presume that the marriage or the law on marriage in China is the same as the law in the Philippines. And in our country, we have to note that a village leader cannot actually perform a marriage. So we call this presumption as processual presumption. The doctrine of processual presumption states that the foreign law, whenever applicable, should be proved by the proponent thereof. Otherwise, such law shall be presumed to be exactly the same as the law of the forum. This doctrine, ladies and gentlemen, was mentioned in the case of Collector of Internal Revenue versus Fisher, decided in January 28, 1961. Ano bang nangyari dito? Ang facts ng case na ito are as follows. Si Walter Stevenson was actually born in the Philippines of British parents and married in Manila to another British subject, Beatrice. So, mag-asawa itong si Walter at si Beatrice. Si Walter actually died in 1951 in California, where he and his wife Beatrice moved to. Sa will ni Walter, he instituted Beatrice as his sole heiress to certain real and personal properties dito sa Pilipinas. And among dito sa property na ito are actually 210,000 shares of stocks in Mindanao Mother Lode Mines. Okay? Tapos, si Ian Morey Stat was actually the appointed ancillary administrator of the estate. Itong si Stat actually filed an estate and inheritance tax return on behalf of the estate of Walter. He then made a preliminary return to secure the waiver of the CIR on the inheritance of the mine shares of stock. And tapos noong 1952, si Beatrice assigned all her rights and interest in the estate of the spouses Fisher, itong respondent sa case na ito. Tapos, in September 7, 1953, itong administrator na si Stat actually filed a second amended estate and tax return on behalf of the estate of Walter. The tax return, declared the same assets of Walter, okay? Except that, may panibagong claims na naka-include doon sa second return niya. Among the claims are the additional exemption and deduction as follows. Una, deduction in the amount of 4,000 pesos from the gross estate of the decedent as provided for, according to him, in Section 861 of the U.S. Federal Internal Revenue Code, which, according to Stat, was allowable dito sa Pilipinas by virtue of the reciprocity agreement as provided for in the National Internal Revenue Code. Yung pangalawa, yung exemption from the imposition of estate tax and inheritance tax on the 210,000 shares of stocks in the Mindanao Mother Lode Mines, Inc. Also, according to him, pursuant to the reciprocity proviso in the National Internal Revenue Code. In this return, itong final ni Stat na return, the estate actually claimed that it was only liable for 525.34 pesos as estate tax and 238 pesos for inheritance tax. And that, as a consequence, sabi ni Stat, nag-overpay sila ng bayad sa gobyerno. So dahil nag-overpay sila sa pagbayad sa gobyerno ng kanilang taxes, sabi ni Stat, we are entitled to a refund of what we paid in the amount of 15,259.83 pesos. Okay? Ang collector naman ng CIR actually denied the claim, and for this reason, an action was commenced in the Court of First Instance, now the Regional Trial Court of Manila, by the respondents' fishers as assignees of Beatrice Mauricia Stevenson for the recovery of the 15,259 pesos, 0.83 centavos. Now, the issue here is this: whether or not in determining the taxable net estate of the decedent, one half of the net estate should be deducted therefrom as the share of the surviving spouse in accordance with our law on conjugal partnership and in relation to the National Revenue Code? Or do we follow the law cited by the administrator stat in this instance? So how did the Supreme Court rule in this case? According to the Supreme Court, in deciding the issue, the lower court applied a well-known doctrine in our civil law that in the absence of any antenuptial agreement, the contracting parties are presumed to have adopted the system of conjugal partnership as to the properties acquired during their marriage. The application of this doctrine to the instant case is being disputed, however, by petitioner collector of internal revenue who contends that pursuant to Article 124 of the new Civil Code, the property relation of the spouses Stevenson ought not to be determined by the Philippine law but by the national law of the decedent husband, and in this case, the law of England. It is alleged by the Collector of Internal Revenue that English laws do not recognize legal partnership between spouses, and that what obtains in that jurisdiction is another regime of property relations wherein all properties acquired during the marriage pertain and belong exclusively to the husband. And to further support his stand, he cited Article 16 of the new Civil Code to the effect that intestate and intestate succession kono, the amount of successional rights among others is to be determined by the national law of the decedent. Pero ang Supreme Court relied on the opinion of Manresa, and they cited as follows. Sabi ng Supreme Court, according to Manresa, the law determinative of property relation of Stevensons married in 1909 would be the English law even if the marriage was celebrated in the Philippines, both of them being foreigners. But, ningon ng Supreme Court, sabi ng Supreme Court, as correctly observed by the tax court, the pertinent English law that allegedly vests in the decedent husband full ownership of the properties acquired during the marriage has not been proven by the petitioner. Except for a mere allegation in his answer, which is not sufficient, according to the Supreme Court, the record is bereft of any evidence as to what English law says on the matter. And in the absence of proof, the court is justified, therefore, in indulging in what Wharton actually calls as the processual presumption, in presuming that the law of England on this matter is the same as our law. So therefore, the Supreme Court in this case finds that the lower court correctly deducted the half of the conjugal property in determining the hereditary estate left by the deceased Stevenson. Okay. We now go to Article 4 of the new Civil Code, which provides that laws shall have no retroactive effect unless the contrary is provided. In general, we have to remember that laws are prospective, not retroactive. Okay? While the judge looks backward, the legislature must look forward. Pasabot, ibig sabihin, the law should always look forward and never backward. If the rule was that laws were retroactive, grave injustice would occur, for these laws would punish individuals for violation of law not yet enacted. And we have to remember that while ignorance of the law does not serve as an excuse, such ignorance refers only to laws that have already been enacted. Okay? Simply stated, when a law is passed increasing the tax brackets for good-looking individuals to be effective on October 20, 2020, the said law cannot impose a higher tax bracket before October 20, 2020 because this will look forward and not backward. Pero, isa ito sa dapat nating i-remember na every rule has an exception. Para lang yung boyfriend mo pag nagkasala, ang general rule, pag nagsorry yan, patawarin mo, di ba? Pero pag ang kasalanan ay talagang grave na, like cheating for instance, ang general rule hindi na yan mag-a-apply. We go now to the exception, which is, hiwalayan mo na. Unless of course, martir ka o sadista na okay lang sa'yo na masaktan. Di ba? Pero ganyan din naman ang batas. May general rule tayo. And in Article 4, ang general rule natin ay ang rule na laws are prospective. Pero may mga exceptions na ang law, pwede na ang application ay retroactive. What are the exceptions? Ang first, if the law provides for retroactivity. Second, when the statute is penal in nature, provided it is favorable to the accused or the convict, and provided further that the accused or convict is not a habitual delinquent. Second, if the laws are remedial in nature. And lastly, is if the law is curative. Now we go to the first exception. The first exception is if the law provides for retroactivity. If ang batas na mismo ang nagsabi na ito ay mag-a-apply retroactively, then we must apply the said law retroactively. Example, when a law is passed condoning the payment of taxes from October 20, 2019 to October 20, 2020, effective October 20, 2020. So, those who failed to pay the taxes from October 20, 2019 to the law's date of effectivity will be condoned since the law actually provides for its retroactive application. Now, this exception also has another exception. It provides that even if the law provides for retroactivity, no retroactive application can be made if the law will become an ex post facto law. When we say ex post facto law, it is one that makes criminal and punishable an act done before the passing of the law and which was innocent when done. Example, kung ang Congress magpapasa ng law na ipipinalize yung mag-unmute ng mga microphones nila during online classes when the professor is speaking, and the law is passed in, say, October 20, 2020. Tapos ikaw, pag September 28, 2020, during your online classes, nag-unmute ka ng iyong microphone at narinig namin yung mga nagbabark mo ng mga dogs at nagtitilaok ng mga manok, diba? The question would be, can you be penalized on October 20, 2020 for what you have done in September 28, 2020? The answer is no. Because if we apply the law retroactively, the same will become an ex post facto law. Walang problema kung ang application is October 20, 2020 onwards. Pero, pag ipapunish ka for what you have done in September 28, 2020, in fact, hindi pa naman crime pag nag-unmute ka noong panahon na iyon, hindi na yan pwede. Kasi, the said law will be considered as an ex post facto law. And this is an express prohibition under our Constitution, which provides that a law that makes criminal and punishable an act done before the passing of the law and which was innocent when done is not allowed under the Constitution. Another kind of an ex post facto law is that one that decreases the quantum of proof for conviction. Ang example nito ay yung crimes, okay? let's say, in a crime of adultery.
In your study of criminal law, you will learn that before a person can be convicted of a crime, kailangan munang i-satisfy ng state ang elements constituting the crime. If say, a crime of adultery, to successfully prosecute the crime of adultery, you need to prove the following elements. First, that the woman is married. Second, that she has sexual intercourse with a man, not her husband. And second, that as regards the man with whom she has sexual intercourse, she must know her to be married. Tapos suppose a law is passed removing the third element, and the law is to take effect in October 20, 2020. Wala itong problema as long as it is not to be given a retroactive effect. You will have an exhaustive discussion on this concept in your criminal law and consti, I believe. Another exception to the prospective application of law is when the statute is penal in nature, provided that it is favorable to the accused or the convict, and provided further that the accused or convict is not a habitual delinquent. An example of this one is the case of People versus Sinosa, which you will see in the following video.
Hi guys, welcome back to my channel. Today we will discuss the case of People versus Sinosa. This case actually led to the development of RA 9262 or VAUSE and released women suffering from Battered woman syndrome from criminal liability in case they commit a crime against their spouse or partners. Ug karon atong maibawan kung unsa na ang Battered woman syndrome ug kung magamit ba ni siya nga depensa kung naa kay makomit nga crime against sa imuhang partner or imuhang spouse as the case may be. So, mag-start na ta sa pag-discuss sa facts sa case sa People versus Sinosa. And of course, as usual, we will start with the parties of the case. Ang parties here are Marivic and Ben, okay? Marivic is the wife, Ben is the husband. So, unsa may nahitabo diri, no? Si Marivic is actually married to Ben, and during pa sa first year sa ilahang marriage, they were actually happy like other couples, no? And then kinadugayan na nga nag-ipon sila, mag-away sila, and kani nga fights would sometimes or would oftentimes lead to violence. Kani magud si Ben is actually palahubog. He's a drunkard, and every time masuko siya or mag-away sila ni Marivic, iyang kulatahon si Marivic. And every time kulatahon niya si Marivic, muli si Marivic sa ilaha. Iguli ni Marivic sa ilaha, apason siya ni Ben. So in town, si Marivic, hoping nga ma-okay ratanan, kay giapas man siya ni Ben, muli sa siya dito sa ilaha. But kani siya, permining nahitabo. Muli si Ben hubog, kulatahon siya, mulaya si Marivic, suyuon na sad niya si Marivic ni Ben, and then mubalik na po si Marivic. This happened for the longest time sa ilahang marriage until one night, si Marivic nga 8 months pregnant, napuno na. Ug sinhitabo diri, si Ben gikulata siya. Apan si Marivic nakadagan siya sa pikas kwarto dito sa kwarto sa ilahang mga anak. And human dito, nagpabugnaw sa siya, and then tungod kay nahadlok man siya sa iyahang bana nga pasakitan na sad siya, unya basig makuhaan sad siya since 8 months pregnant siya, gipatay ni Marivic ang iyahang bana nga natug. Gisod niya dito sa kwarto nga natug ug iyang gipusil. Naturally, gikiha siya sa family ni Ben og parricide, and she was actually convicted. Unya niabot ning kasuha ngadto sa Supreme Court ug niingon si Marivic nga I am actually justified in killing my husband because I am suffering from Battered woman syndrome. And me being suffering from Battered woman syndrome, that should constitute as a self-defense. O kung self-defense na siya, Your Honor, I should not incur any criminal liability since justified ko in killing my husband. So, abot ni sa Supreme Court, and ang issue dito nga niabot sa Supreme Court mao ni whether or not si Marivic can validly invoke Battered woman syndrome as constituting self-defense. So, atong tanawon kung giunsa ni pag-decide sa Supreme Court. Pero ato sa ding tanaw, no, kung kanusa man ka makaingon nga ang babae is actually a battered woman. Tanawon kuno nato giunsa ni pag-storya or pag-desider sa Supreme Court.
Ngayon ng Supreme Court, a battered woman has been defined as a woman who is repeatedly subjected to any forceful physical or psychological behavior by a man in order to coerce her to do something he wants her to do without concern of her rights. Battered women include wives or women in any form of intimate relationship with men. Furthermore, in order to be classified as a battered woman, the couple must go through the battering cycle at least twice. If it occurs a second time and she remains in the situation, she is defined as a battered woman. Kung sa maning kahaang mga personality traits nga gipakita or gi-exhibit sa mga battered women, ningon ng Supreme Court, battered women exhibit common personality traits such as low self-esteem, traditional beliefs about the home, the family and the family sex role, emotional dependence upon the dominant male, the tendency to accept responsibility for the batterer's action, and the false hopes that the relationship will improve. Sadly, no, ang battered women, ang ilahang self-esteem is very low. Unya, ilahag yung pagtuo nga ang babay is of lesser role ikumparar sa usa ka lalaki. Unya, kung kasagaran masuko ang lalaki or kung masuko ang mangulata sa ilaha, feeling nila gikulata sila because sila'y sad-an. Mao kuno na ang common traits nga gi-exhibit sa usa ka battered woman. And more graphically, ningon ng Supreme Court, the battered woman syndrome is characterized by the so-called cycle of violence, which has 3 phases. So, naay cycle of violence ningon ng Supreme Court. Unsa kani nga mga 3 phases sa cycle of violence? Ang una, the tension building phase. Ikaduha, the acute battering incident. O ang ikatulo, the tranquil, loving, or at least the non-violent phase. Karon, sa desisyon sa Supreme Court, iyahag yun nga gi-illustrate kung kanusa na ay tension building phase, kanusa na ay acute battering incident, o kanusa na ay tranquil, loving phase. The Supreme Court said, during the tension building phase, minor battering occurs. It could be a verbal or slight physical abuse or another form of hostile behavior. So dire, nang init na ang ulo sa mangulatahay, okay? So, unya dire sad ang babay, ang battered woman, iyang i-try nga i-pacify ang kalagot sa iyang batterer. Unya ang ikaduha nga phase sa cycle of violence ang acute battering incident. Here, kani nga incident is characterized by brutality, destructiveness, and sometimes, sadly, death. So, dire na gyud mangulata pag-ayo ang batterer. Unya ang babay, dinhi iya na pong ma-realize or ang battered woman dinhi niya ma-realize nga wa na gid siya mahimo para mapugnan ang batterer. And in fact, wala na lang siya buhaton kundi pasagdan na lang si batterer nga gikulata siya. And the final phase here is the tranquil period. The couple here experience a profound relief. Sa lain nga bahin, the batterer may show a tender and nurturing behavior towards his partner. So, ang nangulata, diri sa tranquil loving phase, iyan ang labing-labingon ang iyahang asawa or ang iyang uyab baron or ang iyahang partner as the case may be. Unya, si battered woman sad nga gikulata, feeling sad niya, iya pong sa nganong gikulata siya. Unya, in this case, kay gilabing-labing naman siya, ang iya pong pagtuo nga mausab pa ang batterer. Unya, iyaha na lang pasayloon in this phase. Pero enough ba ni nga mga cycle aron mapatay ni Marivic si Ben? Ningon ng Supreme Court, in any event, the existence of the syndrome in a relationship does not in itself establish the legal right of a woman to kill her abusive partner. Evidence must still be considered in the context of self-defense. In fact, ningon ng Supreme Court, nga settled is our jurisprudence, however, is the rule that one who resorts to self-defense must face a real threat on one's life, and the peril sought to be avoided must be imminent and actual, not merely imaginary. And giklaro sa Supreme Court nga ang unlawful aggression is the most essential element of self-defense. It presupposes actual, sudden, and unexpected attack or an imminent danger thereof on the life or safety of a person. And then the Supreme Court said nga in the present case, however, according to the testimony of Marivic herself, there was a sufficient time interval between the unlawful aggression of Ben and her fatal attack upon him. She had already been able to withdraw from his violent behavior and escape to their children's room. And during that time, he apparently ceased his attack and went to bed. The reality or even the imminence of a danger he posed had already ended altogether, and he was no longer in a position that presented an actual threat on her life or safety. And as a conclusion, in the Supreme Court, we reiterate the principle that aggression, if not continuous, does not warrant self-defense. In the absence of such aggression, there can be no self-defense, complete or incomplete, on the part of the victim. Therefore, in the Supreme Court, Marivic's killing of Ben was not completely justified under the circumstances. So mo to guys, ang People versus Sinosa, it is worth noting no nga despite the affirmation of the Supreme Court on the conviction of Marivic in this case, kani pong kasuha actually led to the development of RA 9262 or Anti-Violence Against Women and Children Act of 2004.
Nga nag-ingon nga if a woman kills her husband or a partner, as the case may be, she will be excused from criminal liability.
So in this case, since self-defense naman yung battered woman syndrome and this is favorable to the accused, it can be given a retroactive application. Exception lang naman sa rule na ito is when the accused is a habitual delinquent. When you say habitual delinquent under the revised penal code, a person shall be deemed to be habitually delinquent if within a period of 10 years from the date of his release or last conviction of a crime of robbery, theft, estafa, or falsification, he is found guilty of any of the said crimes a third time or oftener. And you will have an exhaustive and extensive discussion on this one in your Criminal Law 1 and 2 subjects. Now, another exception to the rule that law shall have prospective application is when the laws are remedial in nature. Ang reason nito is that there are no vested rights and rules of procedure. According to the Supreme Court, remedial statute or statutes relating to remedies or modes of procedure which do not create new or take away vested rights but only operate in furtherance of the remedy or confirmation of rights already existing do not come within the legal conception of a retroactive law or the general rule against retroactive operation of statutes. And the last exception is if the law is curative. It is necessarily retroactive for the precise purpose that it is actually to cure errors or irregularities.
Article 5 provides that acts executed against the provisions of mandatory or prohibitory laws shall be void except when the law itself authorizes their validity. This is quite simple, ladies and gentlemen. This simply means that if you do an act that is against a mandatory or prohibitory law, that particular act shall be considered void. Example is when you donate a parcel of land. Later on in your study of property, you will learn, friends, that a donation of a parcel of land can only be considered valid if the same is reduced in a public instrument. If the donation is orally made or written in a private document, that donation is void. Mao ni siya ang classic nga example sa general rule saying that acts executed against the provisions of a mandatory or prohibitory laws shall be void. Syempre, as what we have mentioned earlier, in almost all cases, every general rule has an exception.
And Article 5 has an exception wherein although violations of mandatory or prohibitory laws result in void acts or contracts, the law in some instances authorizes their validity. Example here is when the law makes an act not void but merely voidable. Later on sa atuang study in this subject, you will learn in marriage that there are several ways to sever or dissolve a marriage. This is either by declaring it void from the very beginning or annulling it depending on the grounds present in a particular case. Now, we talked about an instance where an act is not void but merely voidable. Ang example ani is when the consent of either party is vitiated. Let's say by intimidation. When you say vitiated, dili niya freely given ba ang iyahang consent. So, intimidation in this instance is one of the grounds for annulling a marriage. Ang marriage, direng dapita, dili void, pero voidable. Kung may kag voidable, valid siya until annulled. Okay? While there is no annulment proceedings that is being instituted by the party whose consent is vitiated, dili nimo makonsiderar nga ang kaminyoon is void. It will be considered as voidable. Okay? The marriage remains and continues to be valid unless it is annulled. Alright? Muna siya ang example sa exception here in Article 5. We now move on to Article 6, which provides that rights may be waived unless the waiver is contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person with a right recognized by law. The general rule here is rights may be waived. Pwedeng i-waive nimo ang imuhang katungod. Pwede mong i-waive ang iyong karapatan. Okay? But the exception here is the said waiver must not be contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person with a right recognized by law. Now, what are the requisites for a valid waiver? These are the following. First, the person waiving must be capacitated to make the waiver. Second, the waiver must be made clearly but not necessarily expressed. Third, the person waiving must actually have the right which he is renouncing. Otherwise, he will not be renouncing anything. Fourth, in certain instances, the waiver, as in the express remission of a debt owed in favor of the waiver, must comply with the formalities of a donation. Fifth, the waiver must not be contrary to law, morals, public policy, good customs, and public order, and the waiver must not prejudice others with a right recognized by law. Now, having these requisites in mind, what are the instances wherein rights in a particular instance cannot be waived? Ang una is kanang natural rights such as the right to life. You cannot ask your friend to kill you. That's why euthanasia is not valid or legal here in the country. Ikaduha, kaning mga rights which do not yet exist. Future inheritance cannot be renounced. Kanang imong gi-expect nga dawaton gikan sa imong mga ginikanan or sa imuha barong apuhan depending on the circumstance cannot be waived because these are future pa. Di pa nimo madawat diha when you renounce it. Okay? That's a future inheritance and it cannot be renounced since there's no right that is vested yet until, of course, the death of the decedent. Ikatulo, katong the renunciation of which would infringe upon public policy. The right to be heard in court cannot be renounced in advance. Hence, this kind of confession of judgment cannot be allowed. Another instance is a waiver in advance of the 1-month separation pay because this will be considered as contrary to public policy. When you say public policy, guys, the aim of the state here is promoting the social welfare of the people. Kaya kung imo ning i-violate, of course, ang social welfare will be compromised or will be prejudiced. That's why the state is protecting the social welfare of its people. Another example of this wherein the waiver may actually infringe upon public policy is an instance wherein a scholar nga gigrantan og scholarship would be made to sign a waiver saying nga I will not transfer to another school while the scholarship stands. Otherwise, kung mo transfer man o galing ko to another school, I will be refunding everything that used to be free when I am still a scholar. So that particular waiver is considered by the Supreme Court in the case of Cue versus Arellano University as a void waiver because it is contrary to public policy. Because according to the Supreme Court, the school concerned obviously understands the scholarship awards as a business scheme designed to increase the business potential of an educational institution. Thus conceived, it is not only inconsistent with sound policy, but also with good morals. Alright? So, next is an instance when the waiver is prejudicial to a third person with a right recognized by law. While an heir may renounce present inheritance, that is, inheritance that has already accrued by virtue of the decedent's death, basta atong timan-an, future inheritance, so pag ganani mo na dawat, buhi pa gani ang decedent, ang tag-iyas katigayunan, you cannot waive that particular inheritance. But if ang tag-iya sa katigayunan already died, kana nga time na nakay katungod, nadawat na nimo ang inheritance because inheritance actually accrues from the moment of death of the decedent. Kung nadawat na nimo, kana siya nga waiver will now be considered valid. Apan, if the waiver will prejudice existing creditors, ikaw nga nakadawat sa katigayunan, unya imong gi-waive karon ang katigayunan to the prejudice of all your creditors na kay 5 million nga nadawat nga katigayunan. Unya at the same time, naapog kay 5 million nga utang. Ang imuhang mga nautangan, no, nga naa kay dawatonon nga katigayunan. And in fact, nadawat na gyud nimo apan ikaw imong gi-waive because you don't want to pay your creditors. That particular waiver is not valid. That is not allowed because this will prejudice third persons. The third persons in this instance are your creditors. Okay? So, naghisgot na ta og instances wherein rights cannot be waived or cannot be renounced. We now go to the examples of rights that may be renounced. Una ani are support in arrears for obviously, this is no longer needed for subsistence. When you say support in arrears, you are actually entitled to receive a support for that particular month. Apan ka na nga month, wala ka tagai. Karon nga month, ning dawat ka og support for this particular month. Kanang imuhang wa na dawat nga support previously last month, pwede na nimong i-waive. Pwede ka may luoy, kung nimo pa, oy, sige lang pa, ayaw na lang kog tagai, ana. That's a support in arrears ni accrue naman na niya. It is presumed nga dili naman na nimo kailangan kay last month ang gusto. Pass na kalimutan mo na. Pass na yon. Anyway, if that is a support in arrears, that can be waived. But if it is a future support, ako lang i-waive akong support inig next month, you cannot do that. Okay? But if it's a support in arrears, if it has already accrued, kana siya, pwede na siyang i-waive because the presumption here is this is no longer needed for subsistence. Also, the right to object to a testimony of a wife on information obtained because of her domestic relations with her husband is waived when a husband accused of killing his son does not only deny his guilt but also points to the wife as the killer. Later in your study of law, you will learn that in the Philippines, we have the so-called testimonial privilege. This testimonial privilege or marital privilege communication provides that during the marriage, neither the husband nor the wife may testify for or against the other without the consent of the affected spouse. Of course, ang exception here is kung ang akusado or kung ang kaatbang mismo kay ang imuhang spouse. In this case, akong gi-mention earlier nga ang testimony sa wife would point to the accused husband. And in this case, the husband is deemed to have waived his right to object the testimony of the wife because what the husband did here is he pointed to the wife. Okay? Niingon siya, I am not the accused, I am not the one who killed my son, but it was actually my wife. So in this case, the spousal privilege or the marital privilege, as the case may be, is considered waived. Another example is the right of the accused to be helped by counsel. This may also be waived, provided, of course, the judge informs said counsel of his right. The right of the accused in a criminal case to have a preliminary investigation may actually be waived. The venue of actions may also be waived, but of course not the court's jurisdiction. The distinction between venue and jurisdiction will be discussed sooner in your study of law. Another is, although a tax obligation has already been extinguished by prescription, the taxpayer may waive the benefit granted by law by reason of the said prescription by the execution of a chattel mortgage to secure the payment of the same, as enunciated in Zambrano versus Court of Appeals. Also, another instance is when an individual who accepts the office of an executor or administrator may actually waive compensation, therefore. The right to the back pay of an employee who has been dismissed without any justifiable cause may be waived by him. This is particularly so when he has been put back to work. Also, the failure to ask for vacation or sick leave privileges after a period of more than 5 years constitutes a valid waiver unless the intent of the law granting the same is clearly otherwise. The purpose of the privilege is to give the employee a much-needed rest and not merely an additional salary. The privilege must be demanded in opportune time, and if he allows the years to go by in silence, he is deemed to have waived it. That is in the case of Philippine Airlines Incorporated versus Balangit et al., decided on June 3, 1956. Right? We now go to Article 7. Article 7 provides that laws are repealed only by subsequent ones, and their violation or non-observance shall not be excused by disuse or custom or practice to the contrary. When the courts declared a law to be inconsistent with the Constitution, the former shall be void and the latter shall govern. Administrative or executive acts, orders, and regulations shall be valid only when they are not contrary to the laws or the Constitution. Paragraph 1 talks about the ways on how to repeal a law. Niingon ng Article 7 na laws are repealed only by subsequent ones. Okay? The repeal can either be express or implied. Unsa may express? Kaning moingon mismo ang balaod nga RA 12345 expressly repeals RA 54321. That's an express repeal. Kung may kag implied repeal, that happens when there are inconsistencies between the prior and the subsequent law. Meaning, kung may particular provision ang RA 12345 that is inconsistent with the prior law, which is RA 54321, kanang particular provision or ang kanang particular nga balaod, if it cannot be reconciled or if it cannot exist in harmony, mahimo na siyang impliedly repealed. Second paragraph provides that when the courts declare a law to be inconsistent with the Constitution, the former shall be void and the latter shall govern. And third paragraph provides that administrative or executive acts, orders, and regulations shall be valid only when they are not contrary to the laws or the Constitution. In general, you have to remember that the sources of law are in this article. And in the order of preference, timani nga nag-unag yun na ang Constitution. Okay? It's been said that the river must not rise above its falls. The falls in this particular statement is the Constitution. The river would consist of the laws, the executive orders, administrative acts, and regulations. Okay? Kung naay balaod nga buhaton ang Kongreso, it must not rise above the Constitution. It must not be in violation or it must not be in contravention with the Constitution, because the Constitution is the fundamental law of the land, wherein all laws emanating from it must conform to its provisions. Alright? And it's been said in the second paragraph that when the courts declare a law to be inconsistent with the Constitution, kanang balaura will be considered as void and the Constitution must govern. Also, administrative or executive acts, orders, and regulations, it can only be considered or they can only be considered valid when they are not contrary to the laws and of course to the Constitution. Now on to Article 8. Article 8 provides that judicial decisions applying or interpreting the laws or the Constitution shall form a part of the legal system of the Philippines. Unsa mani nga mga judicial decisions? This pertains only to the decisions of the Supreme Court. Okay? Note that only the decisions of the Supreme Court on cases of first impression and reverse decisions of the Court of Appeals establish jurisprudence or doctrines in the Philippines. Ako lang ni-iklaro that the judicial decisions that is meant in Article 8 are the judicial decisions of the Supreme Court. The decisions of the Court of Appeals have persuasive character. Okay? If the decisions in the Court of Appeals remain unreversed, of course, it will be absorbed in the decision of the Supreme Court. And that will also be considered as part of the legal system of the Philippines. The Supreme Court, by tradition and in all our system of judicial administration, has the last word in what the law is. It is the final arbiter of any justiciable controversy, and there is only one Supreme Court from whose decisions all other courts should take their bearings. Later on in your study of the constitutional law, particularly the part of the government, you will learn that the judiciary, particularly the Supreme Court, is the one that actually interprets the laws. Sila mo'y moingon if a particular law is constitutional or unconstitutional. Sila ang moingon if the law is not in conformity with the provisions of the Constitution. The legislative department, on one hand, kaning Congress, that is composed of the Senate and the House of Representatives, nga controversial kaayo because of the term sharing agreement stuff lately. Ang ilahang role is to make laws, they legislate laws, they amend laws, abolish laws, they repeal laws. Tanan nga pagbuhat sa balaod, pag-usab, pagpapa sa balaod, it's in the legislative department. That's the role of the legislative department. The executive department, on one hand, is the department that executes laws, implements laws. Sila ang mupatuman sa balaod. And if one department would encroach upon the other department, that would be a violation on the principle of the separation of powers. Muna'y common ninyong mabatian sa mga politicians. Now, the question is, kaning mga judicial decisions, are they considered laws? You have to remember that while it is true that decisions which apply or interpret the Constitution or the laws are part of the legal system of the Philippines, still they are not laws if this were so, the courts would be allowed to legislate now, diba? And this will be contrary to the principle of separation of powers. Indeed, the courts exist in order to state what the law is and not for giving it. All right? Now we go to the doctrine of Starry Decisis. Unsa man ning doctrine of Starry Decisis? Please watch it in this video.
Our doctrine of the day is the doctrine of Starry Decisis. Okay? What is the doctrine of Starry Decisis? The doctrine of Starry Decisis simply means let it stand for reason of stability in the law. The doctrine, which is really adherence to precedent, states that once a case has been decided one way, then another case involving exactly the same point at issue should be decided in the same manner. Example of this is when the Supreme Court, let's say in 1990, decides a case allowing the claim of moral damages in case of breach of promise to marry, when in this case the defendant is a foreigner and the complainant was a virgin, a conservative Filipina. And then later on, say in 2000, a case would also be filed with the same set of facts, the same issues, the same claim. So based on the doctrine of Starry Decisis, the decision now would be based on the decision handed down by the Supreme Court in the previous case sometime in 1990. That's just the doctrine of Starry Decisis, the so-called adherence to precedents. Of course, when a case has been decided erroneously, such an error must not be perpetuated by blind obedience to the doctrine of Starry Decisis. We have to remember that no matter how sound a doctrine may be, and no matter how long it has been followed through the years, still, if found to be contrary to law, it must be abandoned. The principle of Starry Decisis does not and should not apply when there is a conflict between the precedent.
Remember that while stability in the law is eminently to be desired, idolatrous reverence for precedent, simply as precedent, no longer rules. More pregnant than anything else is that the court shall be right. That's according to Phil Trust Company versus Merchill. So that's a doctrine of Starry Decisis. Another doctrine or concept that you will be encountering in this article is the so-called Obiter Dicta, or the singular form Obiter Dictum. These are opinions not necessary to the determination of a case. They are not binding and cannot have the force of judicial precedents. It has been said that an Obiter Dictum is an opinion uttered, by the way, not upon the point of question pending. It is as if the court were turning aside from the main topic of the case to collateral subject. Mga pasakalye ba? But these statements are not actually the decision really of the court on the main question or on the point of question pending. But these are just a segue onto other matters or collateral subjects of a particular case. Okay? That's Obiter Dicta, or the singular form Obiter Dictum. Now on to Article 9. Article 9 provides that no judge or court shall decline to render judgment by reason of the silence, obscurity, or insufficiency of the laws. Now, if there is no law and there is a controversy, how will you resolve a legal issue? In the case of Chua Jan versus Bernasno, the case here is about cockfighting. And the Supreme Court said that even if the judge does not know the rules of cockfighting, he must still decide the case. A judge must give a decision whether he knows what law to apply or not. So how do we resolve a legal issue if there is no law, for instance? Okay? According to some of the decisions of the Supreme Court, the judge may actually apply any rule he desires as long as the rule chosen is in harmony with general interest, order, morals, and good customs. And among such rules may be the following. First, customs which are not contrary to law, public order, and public policy, decisions of foreign and local courts or similar cases, opinions of highly qualified writers and professors, the rule on statutory constructions, and the principles laid down in analogous instances. But we have to remember that these circumstances will only apply if there is no law. If there is a law, we use the law. Okay? Parehara na siya in answering your questions in the bar or in the examinations here in law school. Okay? If you know the law, if the question being asked, specifically asked for a specific law, you cite the law. Okay? But if you think that you do not know the answer, that is the time when you improvise. Okay? You will either cite a decision of the Supreme Court and other things nga pwede ninyong maatikan ang inyong examiner. But you have to remember that if you really know the law and you know that what is being asked is that particular law, you always have to cite that particular law. Okay? So that's Articles 5 to 9, ladies and gentlemen. Good day, everyone, and welcome to Persons and Family Relations. Last time we talked about Articles 5 to 9, and today we will discuss Articles 10 to 13 of the new Civil Code. Let's start with Article 10, which provides that in case of doubt in the interpretation or application of laws, it is presumed that the lawmaking body intended right and justice to prevail. Article 10, ladies and gentlemen, according to the Code Commission, is necessary so that it may tip the scales in favor of right and justice when the law is doubtful or obscure. It will strengthen, according to the Code Commission, the determination of the courts to avoid an injustice which may apparently be authorized by some way of interpreting the law. It's been said that the law may be harsh, but it is still the law. Hence, the first duty of the judge is to apply the law, whether it be wise or not, whether just or unjust, provided that the law is clear and there is no doubt. It is the sworn duty of the judge to apply the law without fear or favor, to follow its mandate and not to tamper with it. What the law grants, the court cannot deny. That is what the Supreme Court said in the case of Osego versus Anti-Chinese League of the Philippines. But of course, according to the Supreme Court, in case of doubt, the judge should presume that the lawmaking body intended right and justice to prevail. For after all, the Supreme Court said that it has been truly said that we should interpret not by the letter that killeth, but by the Spirit that giveth life. Now we shall discuss Articles 11 and 12 together, starting off with Article 11. Article 11 states that customs which are contrary to law, public order, or public policy shall not be countenanced. Article 12 provides that a custom must be proved as a matter of fact according to the rules of evidence. Dili kayo ni sikat, hindi masyadong sikat sa bar exams or in your quizzes itong concept ng Articles 11 and 12. But for purposes of having an overview of what is the concept of customs, magstorya tagamay dire, okay? Now, in the case of INRE authority to continue the use of firm name CSIP, the Supreme Court defined custom as a rule of conduct formed by repetition of acts uniformly observed as a social rule, legally binding, and obligatory. Okay? The question here would be, what are the requisites before the courts can consider customs?
we have to consider the following requisites. The first is a custom must be proved as fact according to the rules of evidence. The custom must be or must not be contrary to law, public order, or public policy. There must be a number of repeated acts. Kay kung kausara na siya gihimo, dili na sa custom, okay? The repeated acts must have been uniformly performed. Dapat dili usara pod ang nagbuhat ana in the community. And there must be a juridical intention to make a rule of conduct. And there must be a sufficient lapse of time. Kay kung gihimo na 1 year 2 years, there's no lapse of time. There's no sufficient lapse of time. And it doesn't become a custom. An act does not become a custom. Okay? You have to remember these requisites in order for the court to consider a particular custom as a matter of fact. Now, the question is, how is this proven? A custom must be proved as a matter of fact. That's according to Article 12, no? A custom must be proved as a matter of fact according to the rules of evidence. Ang pasabot ani, ang ibig sabihin lang naman ito ay courts cannot take judicial notice over a custom. It must be proven through the rules of evidence. Ano ba itong judicial notice? Unsa man ning judicial notice? When you say judicial notice, no, this is actually a concept in evidence that refers to the act of the court in taking cognizance of matters as true or as existing without need of the introduction of evidence, or the authority of the court to accept certain matters as facts even if no evidence of their existence has been presented. The action is often expressed, thus the court takes judicial notice of. Okay? So when we say the court cannot take judicial notice of customs or a particular custom, pasabot lang ani, ibig sabihin lang naman ito, kailangan i-prove muna yan. Okay? This has to be proven first nang nag-o-offer and should not be taken by the court automatically as a proven fact. I-prove muna through the rules of evidence, and when we say evidence, it is actually the means sanctioned by the rules of court of ascertaining in a judicial proceeding the truth respecting a matter of fact. Kay just because ni-exist ang usa ka butang, you have to remember na just because ni-exist ang usa ka butang doesn't really mean nga tinuod na. Mura nagpagpanguya ba nga mag-ingon-ingon kay kag I love you lagi day, I love you lagi day, love kay tika. Manguyab gani kag law student or abogada, no? Just you have to expect nga ingnon gyud ka nag, do you have evidence to prove your claim? Parihara na sa judges, ladies and gentlemen. If a custom is introduced to him, it must be proven first before it can be admitted by the court as a matter of fact. Pariha anang, let's say magpa-breed ka o cow, okay, or baka. Customarily, ang arrangement ana, because usara manggoy anak anang baka, no? The baby or the calf, the baby cow, actually goes to the tag-iya of the bayi. And the male cow or the owner of the male cow will only be paid. Let's say 500, 1,000. Depende na siya sa agreement or depende sa custom ana nga particular community. And if naamang gani dispute as to who should get the baby calf, i-present na nimo siya nga customarily ang tag-iya gyud sa bayi ang makakuha sa anak sa baka. Okay? I hope that's clear, ha? Akong balikon customs which are contrary to law, public order, or public policy shall not be countenanced. And a custom, if you will introduce this in court, must be proved as a matter of fact according, of course, to the rules of evidence. Alright? We now move on to Article 13. Article 13 provides that when the laws speak of years, months, days, or nights, it shall be understood that years are of 365 days each, months of 30 days, days of 24 hours, and nights from sunset to sunrise. If months are designated by their name, they shall be computed by the number of days which they respectively have, And in computing a period, the first day shall be excluded and the last day included. Article 13, ladies and gentlemen, speaks of the period as defined by law. This also speaks of how you count the periods. So first we will take on the term year. Year is understood as 365 days in this article, Article 13. Then, a revised administrative code came out, particularly Book 1, Chapter 8, Section 31, and it said that year shall be understood to be 12 calendar months. Month of 30 days unless it refers to a specific calendar month, in which case it shall be computed according to the number of days the specific month contains, day to a day of 24 hours, and night from sunset to sunrise. If you notice, guys, what we have here is a clear conflict. Sa Civil Code manggod, ang year there is 365 days, while in the Revised Administrative Code, ang year is 12 calendar months. Now, the question is this: which between Article 13 of the new Civil Code and Section 31, Chapter 8 of Book 1 of the Revised Administrative Code should govern? In the case of CIR, or Commissioner on Internal Revenue versus Primetown Property, the Supreme Court said that Article 13 has been impliedly repealed by the Revised Administrative Code. So what happened in the case of CIR versus Primetown Property was this: Gilbert Yap, the Vice Chair of Primetown, applied on March 11, 1999 for a refund or credit of income tax which Primetime paid in 1997. So remember, they filed or they applied for a refund on March 11, 1999 for the income tax they paid in 1997. Gilbert Yap claimed that they are entitled to a refund because they suffered losses that year due to the increase of cost of labor and materials. However, despite the losses, they still paid their quarterly income tax and remitted creditable withholding tax from real estate sales to the Bureau of Internal Revenue. Hence, they are now claiming for a refund because according to them, we weren't actually earning anything, but we're still paying taxes. So on May 13, 1999, Revenue Officer Elizabeth Santos required Primetown to submit additional documents to which Primetown actually complied with. However, its claim was not acted upon, which prompted it to file a petition for review in the Court of Tax Appeals on April 14, 2000. The Court of Tax Appeals dismissed the petition as it was filed beyond the 2-year prescriptive period for filing a judicial claim for tax refund according to Section 229 of the NIRC or the National Internal Revenue Code. When we say prescriptive period, this, ladies and gentlemen, is the time limit setting forth the maximum period of time after an event that legal proceedings based on that event may be initiated. In this case, the CTA said, you already went beyond the 2-year prescriptive period, so you can no longer file a judicial claim for tax refund. According to the CTA or the Court of Tax Appeals, the 2-year prescriptive period is equivalent to 730 days pursuant to Article 13 of the new Civil Code. Since Primetime filed its final adjustment return on April 14, 1998, and that year, 2000, was a leap year meaning na ay February 29. The petition was filed 731 days according to CTA after Primetown filed its final adjusted refund. Supposedly, the 2-year period should have been 730 days only, and according to CTA, it's already 731 days because you filed it in 2000 and it is a leap year and sobraan siya isa ka adlaw. Hence, according to the CTA, it's beyond the reglementary period. And hence, Primetown appealed to the Court of Appeals, and then the Court of Appeals reversed the decision of the Court of Tax Appeals. And therefore, this appeal to the Supreme Court. So the issue here is whether or not the petition was filed within the 2-year prescriptive period. The conclusion of the Court of Appeals that the respondent, YAP, filed its petition for review in the Court of Tax Appeals within the 2-year prescriptive period provided for in the NIRC or the National Internal Revenue Code is correct. Its basis, however, is not. The rule is that the 2-year prescriptive period is reckoned from the filing of the final adjusted return. But the question now, according to the Supreme Court, is how should the 2-year prescriptive period be computed? The Supreme Court said that, as already quoted, Article 13 of the Civil Code provides that when the law speaks of a year, it is understood to be equivalent to 365 days. In the case of National Marketing Corporation versus Tixon, the Supreme Court ruled that a year is equivalent to 365 days regardless of whether it is a regular year or a leap year. However, in 1987, Executive Order 292 or the Administrative Code of 1987 was enacted. And Book 1, Chapter 8, Section 3 thereof provides that a year should be understood to be 12 calendar months. Now, the Supreme Court further discussed that a calendar month is a month designated in the calendar without regard to the number of days it may contain. A law may be repealed expressly by a categorical declaration that the law is revoked and abrogated by another, as discussed earlier in our discussion, or impliedly when the provisions of a more recent law cannot be reasonably reconciled with the previous one. Now, you may notice in Book 7, Section 27, in its final provisions, the Supreme Court mentioned that there is a repealing clause which provides that all laws, decrees, orders inconsistent with this code are hereby repealed or modified accordingly. The repealing clause provided for in Section 27 is not an express repealing clause because it fails to identify or designate the laws to be abolished. Thus, the provision specified in Section 27 only impliedly repealed all laws inconsistent with the Administrative Code of 1987. The Supreme Court further said that implied repeals, however, are not favored. An implied repeal must have been clearly and unmistakably intended by the legislature. And the test is whether the subsequent law encompasses entirely the subject matter of the former law and they cannot be logically or reasonably reconciled. This is a bit exhaustive, but it's very important to understand the decision of the Supreme Court with respect to the survival of Article 13, okay? Both Article 13 of the Civil Code and Section 31 of the Administrative Code, particularly Book 1, Chapter 8, deal with the same subject matter. The subject matter in both instances is the computation of legal periods. Under the Civil Code, a year is equivalent to 365 days, whether it be a regular year or a leap year. And under the Administrative Code of 1987, however, a year is composed of 12 calendar months. And needless to state, under the Administrative Code of 1987, the number of days is irrelevant.
there obviously exists in this case a manifest incompatibility in the manner of computing legal periods under the Civil Code and that of the Administrative Code. For this reason, we hold that Section 31, Chapter 8, Book 1 ng Supreme Court of the Administrative Code, being the more recent law, governs the computation of legal periods. So, bago na siya ha. When we talk about year, what now governs is the provision of the Administrative Code, which provides that when we talk about year, it shall mean 12 calendar months. So, if we apply Section 31, Chapter 8, Book 1 of the Administrative Code to this case, ng Supreme Court, the 2-year prescriptive period reckoned from the time respondent filed its final adjustment return on April 14, 1988, consisted of 24 calendar months. And it is computed as follows. Makalingaw kaayo ang Supreme Court in this case because they really illustrated the computation by stating therein how to compute the first month, the second month, from year 1 to year 2. So, this is it. And as a conclusion, the Supreme Court therefore hold that the respondent's petition filed on April 14, 2000 was filed on the last day of the 24th calendar month from the day respondent filed its final adjusted return. Hence, it was filed within the reglementary period. So let us never forget that a year is now defined as 12 calendar months. Okay, remember, a year is now defined as 12 calendar months. This is very simple. In short, the Supreme Court really just said na if we talk about years, we interpret calendar months as how we understand it in its ordinary usage. Example, kung maingon ka og 2 years from now, let's say today is October 12, 2020, 2 years from now, in its ordinary understanding or usage of a calendar month, is October 12, 2022. Okay? You just remember that. A year is 12 calendar months and is understood in its ordinary operation. Say 2 years from today, that's October 12, 2020, is actually October 12, 2022. That's just how simple the Supreme Court reconciled the interpretation of these provisions in Article 13 and that of the Administrative Code. But take note that calendar month in defining a year is not the same month that is used both in the Civil Code and in the Revised Administrative Code. A month is 30 days gihapon. Meaning, if specific ang number of months, you will still count 30 days. Okay? If, let's say, Maria owes Joven a sum of money and Maria promised to pay in 2 months from the execution of the promissory note, say, Maria executed the promissory note on October 8, 2020. Due and demandable na ang obligation ni Maria to Joven after 60 days. Alright? Because a month is equivalent to 30 days and 2 months is 60 days. And the same gihapon yung provision in the days and the nights and so on. Today, we will start discussing Article 14 of the new Civil Code, which provides that penal laws and laws of public security and safety shall be obligatory upon all who live or sojourn in the Philippine territory, subject to the principles of public international law and to treaty stipulations. Ladies and gentlemen, here in the Philippines, we adhere to the doctrine in criminal law known as the theory of territoriality. Alright? Wherein any offense committed within our country offends the state. Therefore, any person, whether citizen or alien, can be punished for committing a crime here. Thus, the technical term generality came into being. It means that even aliens, when we say aliens, mga foreigners not flying aliens or something like that, male or female, come under our territorial jurisdiction. This is because aliens owe some allegiance of sort to our territory, even if it be temporary. When we say living, mailhana dire nagpuyo sa Pilipinas. When you say sojourning, temporary lang ang stay here in the Philippines, okay? Example of this is if, say, Joven, an American citizen, okay, Amerikano si Joven in this case, and he comes to Colon, and then mulabang si Joven sa Colon, unya, nag-jaywalking siya. And then Joven will say, oh, you cannot arrest me for jaywalking, Joe, because I am an American citizen. Joven cannot do that because here in our country, we adhere to the Generality Principle, meaning penal laws and those of public security and safety shall be obligatory upon Joven, even if Joven is an alien in this particular instance. Okay? I hope that's clear. Another thing is, let's say, Joven is prosecuted for, say, rape. This is just an example, Joven, ha? And Joven would say, I cannot be prosecuted for offenses in the Philippines because I am an Americano. Joven cannot say that because as earlier discussed, penal laws are obligatory upon Joven bisan pag Amerikano si Joven. That is what is meant by the Generality Principle. Penal laws as well as of public security and safety shall be obligatory upon everyone, whether living or sojourning in the Philippine territory. But of course, as earlier mentioned, no, every general rule, ang atong general rule is laws are binding to everyone, 'di ba? Whether living or sojourning in the Philippine territory, that's under the Generality Principle. But there is an exception even if that particular person is in our territory, dili siya bound to answer for an offense which he or she may commit here in the country. The exception ani is kaning principles of public international law and treaty stipulations. What is this theory or principle of public international law? This says that immunities granted to diplomatic officials and visiting heads of states, provided the latter do not travel incognito, they are immune from suit, okay, or from criminal prosecutions. Remember that if they travel incognito, when you say incognito, they did not inform our country that they are here and they are heads of states or members of diplomatic, or if they are diplomatic officials, right? But with the knowledge of our government officials, if they travel incognito, heads of states are entitled to immunity. If the incognito travel is without the knowledge or permission of the country, the diplomatic immunity cannot be insisted upon and the heads of states traveling may be arrested. However, once they reveal their identity, of course, the immunity is now given. Example, no, the President of the United States, si Donald Trump, muari siya diri sa Pilipinas, and if he commits a crime, he is immune from criminal prosecution because under Article 14, no, penal laws shall be obligatory upon all who live or sojourn in the Philippine territory, but subject, of course, to the principles of public international law. And the principles of public international law would provide that heads of states are actually immune from criminal prosecution. That's the first exception, ladies and gentlemen, under Article 14. Now, another exception is the Treaty Stipulation. An example of this treaty, no, stipulation is a treaty entered into between the Philippines and the United States. Kinumdo mo atong military basis agreement. I think this has already been abolished. The military basis agreement, the RPUS military basis agreement, entered into between the Philippines and the United States, wherein some provisions would exempt certain members of the armed forces of the United States from the jurisdiction of our courts. If, let's say, kanisiya is still effective, no, ang example ani would be this. Let's say a member of the American military would come here in the Philippines and then would commit a crime, let's say, mang-rape siya. And then, under the RP-US Military Bases Agreement, there's a provision there na if any of the member of the military of the United States would commit a crime here in the Philippines, they shall not be subject to the jurisdiction of the Philippines, but subject to the jurisdiction of the United States of America. Let's say that's one of the stipulations in that particular treaty, the RP-US Military Bases Agreement. The Philippines, in this case, cannot now take jurisdiction over that particular member of the military because of this particular treaty stipulation. Okay? Mao lang na siya ang exception in this particular article, Article 14 of the new Civil Code. Mao na siya ang gi-mention here. Alright? Remember that those exceptions are just the exceptions mentioned in your Article 14 of the new Civil Code. I want to remind everyone na when you're listening to this recording, you must have with you at least your codal provisions or your book in persons and family relations in order for you to have a better understanding of what we're talking about here. Okay? Some of the provisions would later on ensue or would later on be discussed by your professor in your Criminal Law 1, okay? There are a lot of exceptions provided for in your criminal law with respect to the territoriality as well as with respect to the generality principle. So for now, that's just it for Article 14, and we now move to Article 15. Article 15 provides that laws relating to family rights and duties or to the status, condition, and legal capacity of persons are binding upon citizens of the Philippines, even though living abroad. Meaning, whenever or wherever you are, your status will always be governed by Philippine laws. Okay? What do we mean when we say status? When we say status, the status of a person in civil law includes the personal qualities and relations, more or less permanent in nature and not ordinarily terminable at his own will, such as his being married or not, or his being legitimate or illegitimate. Kung minyo ka diri sa Pilipinas, when you go abroad, you are still married. Okay? Kung lalaki ka diri sa Pilipinas, when you go abroad, you are still a lalaki. Okay? You have to remember that. Kung single ka diri, ay, abot ni mo dito, sure ko single yapon ka. Okay? Bouvier's Law Dictionary defines status as the sum total of a person's rights, duties, and capacities. Sanchez-Roman considers civil status the distinct consideration of a person before the civil law. Article 15, ladies and gentlemen, is what we call the Nationality Principle. Okay? Remember that Article 15 refers to the family rights and duties, including the parental authority, the marital authority, support, etc., etc. It also refers to status, the condition, and the legal capacity of a person. Okay? Guys, kanidi ang Article 15 is actually a rule of private international law or conflicts of law. Okay? Later on in your study of law, you will encounter a subject entitled or named conflicts of law. There, you will study the conflicting laws between our domestic laws and international laws. And one of the laws that you will be studying in that subject is Article 15 of the new Civil Code. Example is this. Let's say Joven and Mary are married. And then their marriage here in the country is considered void. Let's say void siya because si Mary was a minor when they got married. Example lang. And then Joseph and Jovelyn, another couple, are also married but also void yapon because let's say in this case si Joseph kay minor when they got married. Okay? And then Joven and Jovelyn met abroad. Niadto sila US because they were working, okay? Si Joven came from a void marriage. Jovelyn also came from a void marriage, okay? So Joven and Jovelyn went abroad in the United States and then they got married there.
The question is this: is the marriage between Joven and Jovelyn valid? Let's just say that in the United States, their marriage was actually valid, okay? And under the principle of lex loci celebrationes, when a contract is valid where celebrated, it will also be considered valid here in the Philippines. Question: will that particular principle, lex loci celebrationes, be made applicable here in the country? Answer is no. The marriage between Joven and Jovelyn is void. Because, actually later in your study in persons, you will learn that there are essential and formal requisites of marriage. Og isa aning mga requisites of marriage is the legal capacity of the contracting parties. And sa legal capacity sa contracting parties, apil ani nga dapat walay legal impediment ang parties. Unsa man ang legal impediment? Pasabot ana nga dapat dili siya minyo when he or she contracts a marriage, okay? And then you might say, "Nya attorney, the marriage between Joven and Mary are actually void man kaha. And then also with Joseph and Jovelyn, void man na siya. So dito valid ilang kaminyoon, pwede ra gyud sila magremarry." It doesn't matter, ladies and gentlemen, ha? Kay ingon ang family code, particularly in Article 40, nga the absolute nullity of a previous marriage may be invoked for purposes of remarriage on the basis solely of a final judgment declaring such previous marriage void. Before na sila magpakasal abroad, before na sila makapakasal og subsequent marriage, no, kailangan i-declare una sa court by final judgment that their previous or their prior marriage were actually void. Okay? So dapat si Joven ning file sa siya og kaso for the declaration of nullity of his marriage with Marie, and Jovelyn also should have done the same. Dili pwede nga sila-sila ray mo ingon nga void among marriage. Dili valid among marriage. So pwede ra may magpakasal sa abroad kay pwede ra didto sa US nga magpakasal basta void ilang marriage diri sa Pilipinas. That cannot be done, ladies and gentlemen. Because the Supreme Court said in Mercado versus Tan nga it is not for the parties kuno to determine the validity of their marriage, but it is for the court of competent jurisdiction to declare the marriage void. Otherwise, it would be so easy for them to be scot-free from liability. Okay? You have to remember this. Bisan pag naa sila sa laing nasod, mubalik gihapon ta sa Article 15 nga nag-ingon, laws relating to family rights, duties, legal capacity of persons are binding upon citizens of the Philippines even though living abroad. Kay minyo man sila diri sa Pilipinas, and even if the said marriage is void, nag-ingon man ang ato ang Philippine law nga kung void imong marriage, ipa-declare sa na nimo nga void before ka makapakasal. Dapat sundo na nila because under the Nationality Principle, binding na nga balaod bisan pag naa sila dito sa abroad. Okay? The same is true between minors. Let's say Joven and Marie got married in the United States of America when they were still 16 years of age. And then in America, let's say valid ang kaminyoon, bahalag 16 years old mo. Igabot diri sa Pilipinas, pangutana, will that marriage between Joven and Marie be considered valid? The answer is no. Because legal capacity of persons, in order for them to get married, the contracting parties must be at least 18 years of age. Balik gihapon ka sa Article 15 nga laws relating to the legal capacity of persons are binding upon citizens of the Philippines even though living abroad. You have to remember that, guys. Okay? That's the Nationality Principle. We now move on to Article 16 of the new Civil Code. It states that real property as well as personal property is subject to the law of the country where it is situated. However, intestate and testamentary successions, both with respect to the order of succession and to the amount of successional rights and to the intrinsic validity of testamentary provisions, shall be regulated by the national law. Timan national law of the person whose succession is under consideration, whatever may be the nature of the property and regardless of the country wherein the said property may be found. Okay? This is another conflicts rule on property. This is the so-called Rex Re Sete. Tanawa ning first paragraph, guys. Balik ko na to. Real property as well as personal property is subject to the law of the country where it is situated. This is the so-called doctrine of Lex Re Sete. Ang pasabot lang ani nga properties, whether real or personal, are as a rule governed by the doctrine of Lex Re Sete. Unsa dining Lex Re Sete? This means that the law of the place where the property is situated should govern the property relations of the same. You have to remember that it is inevitable that the rule should be thus for real property, for after all, real property is attached to the soil or to the land, and a contrary rule may render a judgment on the land ineffective or incapable of enforcement. You might ask, unsa maning real property? Unsa maning personal property? When we talk about real property, these are immovables. Property that cannot be transferred from one place to another, such as land, building. Kana, mga real property na siya. And when we talk about personal properties, these are movables. These are properties which can be transferred from one place to another. A car, a table, a chair, sinina nimo. These are personal properties, okay? Upon the other hand, the rule enunciated under the new civil code for personal property actually changes the old rule. Because in the past, under the old civil code, no, ang kaning personal property will follow the owner. So, sa una, personal property follows the national or the domiciliary law of the owner under the doctrine of mobilia sequentur personam. However, under the new civil code, there has been a great increase in the amount and variety of personal property not immediately connected with the person of the owner. And it was deemed advisable by the Congress of the Philippines to adopt the doctrine of Lex Re Sete, also to movable. So now, there is no more any distinction as to what principle or doctrine should govern with respect to both real and personal properties. Basta maghisgot kag real property as well as personal property, it shall be governed or it shall be subject to the law of the country where it is found. Kung asa na nimo makitaan, the law that should govern over that particular property should be the place or the law of the place where it is situated. Okay? Now, let's see if the shares of stocks or what law should govern with respect to the shares of stock. Remember that a foreigner can actually own a share of stock here in the Philippines, right? So shares of stock of a foreigner, even if personal property, can be taxed in the Philippines so long as the property is located in this country. Also, you have to remember that bank deposits in the Philippines, even if they belong to a foreigner, may also be a subject of attachment proceedings because naaman diri, and the doctrine or the law that should govern should be by virtue of the doctrine of Lex Re Sete. Taxes may also be imposed on dividends from shares in a gas corporation situated in the Philippines, even if the stockholders do not reside here in the country. Okay, we have to remember that principle, Lex Re Sete, law of the place where the property is situated. Now, Lex Re Sete or the Lex Situs rule has an exception. And the exception is also found in the same article, in Article 16. That is found in the second paragraph. Niingon ang second paragraph nga, however, intestate and testamentary succession, both with respect to the order of succession, to the amount of successional rights, and to the intrinsic validity of testamentary provisions shall be regulated by the national law of the person whose succession is under consideration. And ningon pagyud ang second paragraph in Article 16, whatever may be the nature of the property and regardless of the country where the said property may be found. Thus, the following matters are governed not by lex situs but by the national law of the deceased as follows. Una, the order of succession. Ikaduha, the amount of successional rights. When we say amount of successional rights, this refers to the amount of property that each heir is legally entitled to inherit from the estate available for distribution. Next, intrinsic validity of the provisions of the will. Example, whether there be a disinheritance or whether the disinheritance has been properly made or not, or whether the testamentary disposition can be given effect or not. And then the last one is the capacity to succeed. Okay? Example ani is a Filipino couple. A Filipino couple is are vacationing abroad. And then the husband, in this case, instituted the wife as his sole heir. Okay? Niingon ang bana, pinangga kay nako akong asawa, I will institute my wife to be my sole heir. But here in the Philippines, both the wife and the husband actually left 10 children. 10 children na po ka mga anak, okay? Let's say if the husband would die in the US, and if it is probated there, if the will is probated there, is the will valid? The question now is the will executed by the husband in the United States of America, instituting as his sole heir the wife, be considered valid? The answer is, of course, no. Because the second paragraph of Article 16 provides that intestate and testamentary succession, both with respect to the order of succession, to the amount of successional rights, and intrinsic validity of testamentary provision, shall be regulated by the national law of the person whose succession is under consideration. Kinsa man ang person whose succession is under consideration here? It is the husband who executed the will outside of the country. Okay? The husband who executed the will in the United States of America. Article 16, paragraph 2 provides that ang provisions in that particular will shall be regulated by his national law. What is his national law? Philippine law. And according to Philippine law, ang person has the so-called compulsory heirs. Unya, kung naa siya ay compulsory heirs, ang compulsory heirs will be entitled to the so-called legitim. And this legitim is reserved by law and must not be impaired. Meaning, kung manghatag ang nagbuhat og will, dapat dili ma-impair ang legitim sa iyahang mga compulsory heirs. Kinsa may mga compulsory heirs? Who are these compulsory heirs? These are the children. The spouse is just one of the compulsory heirs. So in this case, klaro kaayo nga the legitim of the children of the husband and the wife was actually impaired, and thus that will not be considered valid. I hope that's clear, ha? And now another principle that you will encounter in this particular article is the Renvoice Doctrine. Okay? The Renvoice Doctrine. This Renvoice literally means a referring back. Okay? It literally means a referring back. The problem arises when there is doubt as to whether a reference in our law or to a foreign law should be made. Ang example ani is, let's say there is an American and then he is domiciled in this country, and then when he was here, he dies. And if he dies, the question would be what law should govern his succession. So, under the Renvoice Doctrine, you will refer the issue unto the national law of the decedent. In this case, the alien. Diba? So, inig-adto dito Tanaw ni mo unsa may iyang national law. It's an American law. When you go to America, the America will now say, oh, you refer this back to the Philippines. Because under our law, kung asa siya na domicile, it should be the law that should govern his successional rights. Perhaps the very first case where our Supreme Court has been able to expand at length on what we ought to do when confronted by the Renvoice problem is the case entitled In the Matter of Testate Estate of the Deceased Edward Christensen versus Helen Christensen Garcia. Okay? Ang salient facts of this case are as follows. Edward Christensen, though born in New York, migrated to California, where he resided and consequently was considered a California citizen for a period of 9 years. Okay? Now, in 1913, he came to the Philippines, where he became a domiciliary till the time of his death. However, during the entire period of his residence in this country, he had always considered himself a citizen of California. And in his will executed on March 5, 1951, he instituted an acknowledged natural daughter named Maria Lucy Christensen as his only heir. But he left a legacy of a sum of money in favor of Helen Garcia. Si Helen was considered to be an acknowledged natural daughter of Edward. So, ang counsel for Helen claims that under Article 16, Paragraph 2 of the Civil Code, California law should be applied because he is a national of California. And that under California law, the matter is referred back to the law of the domicile. That therefore the Philippine law is ultimately applicable, and that finally the share of Helen must be increased in view of the successional rights of illegitimate children under Philippine law. Upon the other hand, the counsel for Maria Lucy contends that inasmuch as it is clear that under Article 16, Paragraph 2 of our Civil Code, the national law of the deceased must apply, our courts must immediately apply the internal law of California on the matter, that under California law, there are no compulsory heirs, and consequently, a testator could dispose of any property possessed by him in absolute dominion, and that finally, according to Maria Lucy, the illegitimate children not being entitled to anything under California law, the will of the deceased giving the bulk of the property to Maria Lucy must remain undisturbed. Kaya ang argument manggod rin ni Helen, since I am an acknowledged illegitimate child, I am entitled to my legitim. Because as earlier stated, no, ang compulsory heir would consist of the children, whether legitimate or illegitimate. Basta acknowledged lang ang mga illegitimate, entitled siya to a legitim, which is one half of the share of a legitimate child. Okay? So, ang ingon rin ni Helen, since I am an acknowledged natural child, I am an acknowledged illegitimate child of Edward, and under California law, the law that should govern should be Philippine law because this is being referred back here to our country, I am entitled to more than just the sum of 3,000 pesos nga legacy because 3,000 na may gihatag sa iya nga legacy in this case. Si Maria Lucy on one hand would argue, since Edward in this case is a California citizen, the law that should govern is the internal law of the California. So you apply the California law, and in California law wala man sila gitawag dito nga compulsory heirs. So dili bound si Edward over that particular argument of Helen nga entitled siya to a legitim. So this issue reached the Supreme Court. And the Supreme Court decided to grant more successional rights to Helen. And it said in effect that there are two rules in California on the matter. First, according to the Supreme Court, the internal law which should apply to Californians domiciled in California, mo ng internal law. Gi-explain sa Supreme Court, the internal law, Maria Lucy, should apply only to Californians who is domiciled in California. and the conflicts rule which should apply to Californians domiciled outside of the California. So duha siya, ang internal o ang conflicts rule. Okay? The California conflicts rule found that if there is no law to the contrary in the place where personal property is situated, it is deemed to follow the person of its owner and is governed by the law of his domicile. Edward being domiciled outside California, according to the Supreme Court, the law of his domicile, the Philippines, ought to be followed. Were we to throw back the matter to California, the problem would be tossed back and forth between the states concerned, resulting in international football. Mao na giingon sa Supreme Court. So, the case was remanded to the trial court for further proceedings in order for the trial court to determine the successional rights of the parties under Philippine laws. So that, ladies and gentlemen, is the case of in the matter of the estate of deceased Edward Christensen versus Helen Christensen Garcia. Now on to Article 17. Article 17 provides that the forms and solemnities of contracts, wills, and other public instruments shall be governed by the laws of the country in which they are executed. When the acts referred to are executed before the diplomatic or consular officials of the Republic of the Philippines or in a foreign country, the solemnities established by the Philippine laws shall be observed in their execution. Prohibitive laws concerning persons, their acts or property, and those which have for their object public order, public policy, and good customs shall not be rendered ineffective by laws or judgments promulgated or by determinations or conventions agreed upon in foreign country. The first paragraph of this article lays down the rule of lex luce celebrationes insofar as extrinsic validity or the forms and solemnities is concerned. Thus, a contract entered into by a Filipino in Japan will be governed by Japanese laws insofar as the forms and solemnities of the contract are concerned. However, formalities of the acquisition, encumbering, and alienation of property shall be governed not by lex luce celebrationes but by lex re site. Example, in Japan, a Filipino sold to a Filipino a parcel of land located in the Philippines. The law that should govern the formalities of the sale should be the law of the Philippines because the law is or because the land is located here in the Philippines. This is an exception to the principle of lex luce celebrationes. Okay? Now, also remember the rule of exterritoriality, wherein even if the act can be done abroad, still if executed before Philippine diplomatic and consular officials, the solemnities of Philippine laws shall be observed. The theory is that the act is being done within an extension of Philippine territory. And this is the so-called principle of exterritoriality. I'm sure you've also discussed this in your criminal law. Now, the third paragraph, ladies and gentlemen, gives one exception to the rule that a foreign law, contract, or judgment can be given effect. The reason is that public policy in the Philippines prohibits the same. Example of an act that is prohibited here in the country, even if abroad it is allowed, is a contract for the sale of human flesh or prostitution. Even if the said contract is valid where it is made, it cannot be given effect here in the Philippines because it is against our public policy. Okay? Also, an absolute divorce granted to Filipinos abroad. Even if it is valid where given, it cannot be recognized here in the Philippines because under Article 50 relating to family rights and duties or the status, condition, and legal capacity are binding upon citizens of the Philippines even though living abroad, and under our family code, absolute divorce is not allowed, okay? Except, of course, insofar as our Mohammedan Filipinos are concerned. Because Muslims can actually file for an absolute divorce, okay? Now, the last article that we shall tackle today is Article 18. In matters which are governed by the Code of Commerce and special laws, their deficiency shall be supplied by the provisions of this code. Remember that in case of conflict with the Code of Commerce or special laws, the Civil Code shall only be suppletory, except if otherwise provided for under the Civil Code. In general, therefore, in case of conflict, the special law prevails over the Civil Code, which is general in nature. So guys, remember the important principles in Articles 14 to 18. In Article 14, remember the principle or theory of generality. In Article 15, you remember the nationality principle. Article 16, you remember the principle or the doctrine of lex re sete. Okay? And of course, the exception to the doctrine of lex re sete, which is also the nationality principle. In Article 17, you also remember therein the principle of lex luce celebrationes. Alright? And of course, the rule of exterritoriality. Article 18, the conflict between the Civil Code and other special code. Now, discuss Chapter 2, the provisions on human relations. The law provides in this chapter the basis for liability. Ang pinakasikat yun actually is when you violate a law, you are liable. But this chapter expands the basis of liability. According to the Code Commission, this is calculated to indicate certain norms that spring from the fountain of good conscience. These guides for human conduct should run as good threads through society to the end that law may approach its supreme ideal, which is the sway and dominance of justice. So let's now start with Article 19. Article 19 provides that every person must, in the exercise of his rights and in the performance of his duties, act with justice, give everyone his due, and observe honesty and good faith. Article 19 of the new Civil Code, ladies and gentlemen, is reflective of the universally accepted precept of abuse of rights, one of the most dominant principles which must be deemed always implied in any system of law. It actually parallels to the supreme norms of justice which the law develops and which are expressed in three familiar Latin maxims: Anesti vivier, alterum non ledere, and Ius suum secet trebior, or to live honorably, not to injure others, and to render to every man his due. So, abuse of rights, no? There is a right, you exercise your right. When you have a right, you actually have an option, no, to exercise your right, or you perform your duty. In the performance of duty, wala kay option but to perform it. So, in these particular instances, you can still be liable under this article. Now, abuse of rights would come in if there is an existence of a legal right or duty which is exercised in bad faith for the sole intent of prejudicing or injuring others. Putlan kag kurinte, this cannot be cut off automatically. Before this is done, there has to be notice first. Mauna nga, you may notice no in your bills kanang sa VECO or other electric companies, if ma-reach na kag, I think second or third bill, there's already a notice enclosed in that bill nga ma-disconnect na ka within, let's say, 48 hours upon receipt of the bill kung di ka makabayad. Because they, in this case, the VECO or any electric company for that matter, is now complying with the requirement that there has to be notice first before i-cut off ang imuhang electric connection. Kaya sa una, di kay kakabayad, putlon manday nila. And a lot of people have been complaining. And this is the remedy done by the electric companies
because this is what the law says. Before you exercise your right, you have to exercise it with justice. You give everyone their due, and you have to observe honesty and good faith. But you also have to remember the concept of damnum absque injuria, wherein just because someone got hurt doesn't mean that the other party is liable already. Okay? Example, there is an exercise of a right. If somebody gets hurt, one cannot be held liable. Example, if you have a property and you fence it, you have the right to fence it. Nya, kung ma-injure mo ang silingan, na-hurt siya kay mo ang gi-fence, di na siya kaagi, well, wala may damage because it's your property, so that silingan cannot be held liable. Except, of course, later in your study of property, no, when there is already an establishment of a right of way, kana di na pwede. But if in this case, imo lang gikural imong property for security purposes, there's no damage, although nalain siguro imong silingan, but he cannot claim for damages because in this case, the principle of damnum absque injuria, damage without injury, would come in. Also in contests, kanang mga go-kart racing, diba? They have their own rules and the law will not interfere with that. Kung napildi ka sa go-kart racing, you cannot go to court by saying, oh, napildi ko because the judges saying, maona, because they have their own rule. Now on to Article 20. Article 20 provides that every person who, contrary to law, willfully or negligently causes damage to another shall indemnify the latter for the same. The article punishes illegal acts whether done willfully or negligently. Thus, in the law of torts and quasi-delicts, which you will study later on in law school, whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. Article 21. Article 21 provides that any person who willfully causes loss or injury to another in a manner that is contrary to morals, good customs, or public policy shall compensate the latter for the damage. During the discussion of the Code Commission, a question was raised to the effect as follows. Would not Article 21 obliterate the boundary line between morality and law? And the answer is that in the last analysis, every good law draws its breath of life from morals, from those principles which are written with words of fire in the consequence of man. Furthermore, there is no belief of more baneful consequences upon the social order than that a person may with impunity cause damage to his fellow men so long as he does not break any law of the state, though he may be defying the most sacred postulates of morality. What is more, the victim loses faith in the ability of the government to afford him protection or relief. And later, a question was asked if breach of promise to marry is actionable. Let us now see the answer in the following video clipping.
Ang pangutana is this: is breach of promise to marry actionable? Kung ugaling man sa aran kaniya nga pakaslan, apan di ay to later igo ra kabiyahan, pwede ba nimo siyang ikiha? Kana ato ang sutaon karong hapuna. Well, in the past, it's been clear nga kung there's a breach of promise to marry, unya naanay mga actual nga mga expenses nga na-incur, meaning nakagasto na ka for the gown, for the coat, for the venue, for the catering, for your entourage and all, nagpalit na kag kanding, nagpalit na kag baka, baboy, unsa pariha nga lapaunon para sa inyuhang kaminyoon, kana siya pwede na nimong mapaningil or you will be compensated in the form of actual damages sa imuhang mga expenses nga nagasto because sa iyang breach sa iyang promise to marry you. But what if ang failure is to comply with the promise itself? Meaning, wa siya nagpakasal nimo and
sexual consideration has already been given tungod sa iyang saad, imo nang nahatag tanan bisag 1% wa na habilin, pangutana, pwede ba nimo siyang ikiha for damages? In the past, niingon ng Supreme Court, no. But this ruling or this rule has been modified in the case of Batch versus Court of Appeals. So, unsa may nahitabo aning kasuha? Muna'y akong i-share ninyo karong hapuna ang kaso sa Batch versus Court of Appeals. So, unahon na to, of course, ang parties sa case. Ang parties here are Batch and the second one, ang babae, si Marilu. Okay? Si Batch ang lalaki, si Marilu ang babae. So, si Marilu in this case, nikiha siya for damages under Article 21 of the New Civil Code. Ang Article 21 of the New Civil Code niingon nga, any person who willfully causes loss or injury to another in a manner that is contrary to morals, good customs, or public policy shall compensate the latter for such damage. So karon niingon si Marilu, iyang gisaad nako nga iya kong pakaslan apan di ay to iya ra kong gibiyaan. So ako siyang ikiha karon, Your Honor. What happened here is this: si Marilu in 1987, August 1987, was 22 years old, a Filipina, and according to her, she's a pretty lady and of good moral character and reputation in the community. Si Baksh, on one hand, is an Iranian, an exchange student of the Lyceum Northwestern College in Dagupan City. Nagkaila sila dito. Unya, ning saad si Baksh niya nga kung imo lang gyud kong sugton, imo lang gyud ning dawato na kung gugma nimo, pakaslan ti ka, Marilu. So gumikan aning mga panaad ni Baksh, si Marilu iyang gidawat ang gugma ug mga panaad ni Baksh. Okay? So because of that, niingon man si Baksh, August maruno, by the end of the semester inig October, pakasal na yun ta. Ikaw man gyud ako ang love gyud magigay kay tika. So mo to gisugot ni Marilu, and in fact si Marilu gi-live-in na ni Baksh after ato. So ning uli si Marilu, months after atong ilahang panag-uyab ug panag-live-in, ni uli sila sa probinsya nila ni Marilu, gidani si Baksh kay para makapananghid si Baksh nga pakaslan siya. So ang mga ginikanan sa dintaw ni Marilu, very supportive, very conservative also. Iya pong gidawat wholeheartedly si Baksh. Unya nagpreparar na sila para sa supposed nga kaminyoon nila ni Baksh. But niabot ang October 1987, October on the same year, ang mga panaad ni Baksh nahog ra gyud nga igo ra gyud nga saad. So naabot sila sa barangay for a confrontation, and then gi-allege didto ni Marilu nga gikuha ni Baksh ang iyang pagkababay, unya igo ra gyud siyang gisaaran kay para lang gyud mapuyo siya in the same roof as Baksh. And then it was also found out nga gipalaya siya ni Baksh o giingnan siya ni Baksh nga unsaon ako pagpakasal nimo nga minyo naman kong daan. The question is this: is the breach of promise to marry actionable? Si Baksh makabayad ba og damages diri ni Marilu sa iyang wa pagtuman sa iyang saad nga pakaslan si Marilu? So mao ni ang tubagon nato karong hapuna. Giunsa ka ni pagdesider sa Supreme Court? Let's try to find out. So the Supreme Court said nga that where a man's promise to marry is in fact the proximate cause of the acceptance of his love by a woman, and his representation to fulfill that promise thereafter becomes the proximate cause of the giving of herself unto him in a sexual congress, proof that he had in reality no intention of marrying her, and that the promise was only a subtle scheme or deceptive device to entice or inveigle her to accept him and to obtain her consent to the sexual act, could justify the award of damages pursuant to Article 21 of the new Civil Code, not because of such promise to marry, but because of the fraud and the deceit behind it and the willful injury to her honor and reputation which followed thereafter. So ningon ng Supreme Court, kung pagsugod pa lang ang imo ra gyud intensyon kay ilaron ra gyud siya, unya nisaad ra gyud ka kay aron ilaron ra gyud siya, unya ang babae ni give in gyud tungod sa imong pagpangilad niya, in this case you will be held liable for damages under Article 21 of the new Civil Code. So that's it guys for the case of Baksh versus Court of Appeals.
What's up, online students? Simula na naman ang bagong school year. At naku, malaki ang i-adjust natin. Ngayong tayo ay humaharap sa krisis dulot ng pandemya. Lalong-lalo na kung naka-enroll sa online class. Kaya naman, to make things better while studying online, narito ang iilang mga tips kung paano mo mapapangalagaan ang iyong data privacy while using the e-learning platforms.
Create strong passwords. Mahalaga ang bawat pag-login mo kaya dapat lang panatilihing secured ang account mo with a strong password. Make sure that your password is as strong as you. Madalas, sa public wifi nangyayari ang mga di inaasahan. Di mo alam, maraming oportunista na nakiki-access pag libre ang wifi access. Kaya, connect with reservations. Connect only to networks which have passwords and are inaccessible to all. Maliban sa dapat nagising ka sa klase, dapat stay conscious ka rin sa na-share mo sa video. Mas mabuti nang makasiguro. Use fun and cute backgrounds para walang makakaalam sa iba pang personal information na maaaring makita sa likod mo. Lastly, don't leave traces. Di lahat ng files mo ay shareable. Burahin mo din yan pag may time.
We all know that bad guys are now invading the World Wide Web. Kaya, manigurado na tayo online students. Always protect your privacy, safety, security, and trust online.
Now on to Article 22. Article 22 provides that every person who, through an act of performance by another or any other means, acquires or comes into possession of something at the expense of the latter without just or legal ground, shall return the same to him. Example, na kawatan, gigukod siya sa pulis, unya ang katong kawatan, gibili niya sa imuha, gibutang niya sa imong bag pagdaga niya ang iyahang gikawat. The question, na ba kay sala? Of course, no. But do you have the obligation to return sa object nga gikawat atong kawatan? Yes, because under the law, you acquire something at the expense of the latter without just or legal ground. So your obligation is to return the same to him. Another example, kung si Joven owed Marie a sum of money evidenced by a promissory note, and at maturity, si Joven paid and a receipt was given to him. But when later on he was asked again to pay, he could not find the receipt. So to avoid trouble, he paid again. And then subsequently, he found the missing receipt. The question now is, can Joven get back what he had intentionally but unwillingly paid? The answer is yes in view of Article 22, which incidentally treats of an action in rem verso or unjust enrichment. Another example kanang common kaayo nato nga masinati, no? Pananglitan ning pliti ka unya gisuklian kag sobra sa supposedly isukli sa imuha. Naa ba kay obligation to return the sobra? Well, under this provision, the provision on unjust enrichment or action in rem verso, you have the obligation to return it because you actually acquired it without just or legal grounds. Sobra ang sukli, so ang sobra dapat imong iuli. Nakay nakitaan nga butang nga dili imuha. Imuha na ba na? Kay imuhang nakitaan, finders keepers, nga na, dili. Your obligation is to return it to the owner. Okay? Because by virtue of the principle of unjust enrichment, you have the obligation
to return the same. Article 23 provides that even when an act or event causing damage to another's property was not due to the fault or negligence of the defendant, the latter shall be liable for indemnity if through the act or event he was benefited. Benefit under certain circumstances can be basis for liability. Example, nagbagyo, unya naay cattle naadto sa farm ni, let's say, Joven. Unya, na-save ang cattle. But the crops of Joven were destroyed. Can Mary, let's say si Mary ang owner sa cattle, can Mary now be liable for the damages over the crops of Joven nga na-destroy because of the cattles? The answer is yes, because naay benefit on the part of Mary. But if namatay ang cattle, dili liable si Mary nga tukang Joven because wala may benefit nga na-obtain on the part of Mary. Okay? Article 24. In all contractual, property, or other relations, when one of the parties is at a disadvantage on account of his moral dependence, ignorance, indigence, mental weakness, tender age, or other handicap, the courts must be vigilant of his protection. What is the reason, ladies and gentlemen, for the court's protection of the underdog? The Code Commission says that the law takes great interest in the welfare of the weak and the handicapped. Thus, parens patriae, or the father or the parent of his country. Literally, when you say parens patriae, it's the father or parent of his country. The phrase actually refers to the sovereign power of the state in safeguarding the rights of the person under disability, such as the insane and the incompetent. Thus, were the law always to be applied strictly, there would be danger that injustice might arise. The state, as parens patriae, is under the obligation to minimize the risk to those who, because of their minority, are as yet unable to take care of themselves fully. Article 25. Thoughtless extravagance and expenses for pleasure or display during a period of acute public want or emergency may be stopped by order of the courts at the instance of any government or private charitable institution. Thoughtless extravagance, ladies and gentlemen, during emergencies may incite the passions of those who cannot afford to spend it. That is the reason for curtailing thoughtless extravagance. Now, the question is, who can bring the action? Can Kibuloy just say, stop the thoughtless extravagance? No, it cannot be done. A court action must be brought, okay? And only a charitable institution, whether it be a government or a private institution, may bring such action. Similarly, the mayor of a city, should he desire to stop an alleged display of extravagance by a social organization, cannot summarily order the stopping all by himself. He has to ask for a court order, and a mayor indeed cannot just take the law into his own hands, no matter how noble or sincere his motive may be. Remember the phrase, court order, okay? Before you can stop thoughtless extravagance. Parihara na sa kaning mga nagbash ni Jinky Pacquiao nga dapat di kuno mag-display o extravagancy Jinky Pacquiao kay daghang gipang gutom amid the pandemic. You cannot just bash her to encourage her or discourage her maybe to display those extravagance. Kailangan there has to be a court order. Okay? Now, unto Article 26. Every person shall respect the dignity, the personality, the privacy, and peace of mind of his neighbors and other persons. The following and similar acts, though they may not constitute a criminal offense, shall produce a cause of action for damages, prevention, and other relief. First, prying into the privacy of another's residence, meddling with or disturbing the private life or family relations of another, intriguing to cause another to be alienated from his friends, vexing or humiliating another on account of his religious beliefs, lowly station in life, place of birth, physical defect, or other personal condition. This article, ladies and gentlemen, enhances human dignity and personality. Social equality is not sought but due regard for decency and propriety. Okay? Remedies here, if any of the following would occur, kaning prying into the privacy, meddling with or disturbing, intriguing, vexing, you may institute an action for damages, action for prevention, or other relief. Okay? And this may be instituted if walay criminal action nga ma-involve. You are only asking for moral damages in this case. Alright? When you say prying into the privacy of another's residence, this would include by implication respect for another's name, picture, or personality, except of course insofar as is needed for publication of information and pictures of legitimate news value. When you say meddling with or disturbing the private life or family relations of another, this would include alienation of the affections of the husband or the wife. Thus, a girl who makes love to a married man, even if there be no carnal relations, disturbs his family life, and damages may therefore be asked of her. Intriguing against another's honor or gossiping is also included in this particular paragraph. Intriguing to cause another to be alienated from his friends. This would include gossiping and reliance on her say. Sikag panglibak sa imong silingan. Unya, ang nahimong effect ani is na-alienate na siya from his or her friends. Kana siya nga na-alienate ka ng tao nga inyong gisigiglibak may actually claim for damages or may institute an action to prevent you from furthering your intriguing. And when you say vexing or humiliating, this would include criticism of one's health or features without justifiable cause. Okay? Another example, guys, karong mga panahon na uso na magining installation of CCTV cameras, no? And let's say ikaw, sikat ka sa inyong lugar kay ka-afford ka og patao daw CCTV, gibutangan nimo tanan nimong area. Unya sa imong ka-excited sad giapila nimo butang ang area sa imong silingan. Unya makita gyud nimo ang tugkaran hasta ang ilang sala unsa gibuhat sa imong silingan. Can you do that? Can you cover in your installation the part wherein makita ang tugkaran sa imong silingan, ang balay sa imong silingan? The answer, of course, under Article 26 is no. Such installation, however, should not cover places where there is reasonable expectation of privacy. Unless, of course, the consent of the individual whose right to privacy would be affected was obtained. Timan ilang yun na nga one of the enshrined rights in the Constitution sa individual is the right to privacy. And if there is reasonable expectation of privacy, that should remain inviolable, that should not be contravened, that should not be violated, except of course with the consent of the person whose right to privacy would be affected. We will just run through some of the provisions sa Article 27. Any person suffering material or moral loss because a public servant or employee refuses or neglects without just cause to perform his official duty may file an action for damages and other relief against the latter, without prejudice, of course, to any administrative disciplinary action that may be taken. Article 28. Unfair competition in agricultural, commercial, or industrial enterprises or in labor through the use of force, intimidation, deceit, machination, or any other unjust, oppressive, or high-handed method shall give rise to a right of action by the person who thereby suffers damage. Article 29. When the accused in a criminal prosecution is acquitted on the ground that his guilt has not been proved beyond reasonable doubt, a civil action for damages for the same act or omission may be instituted. Such action requires only a preponderance of evidence. Upon motion of the defendant, the court may require the plaintiff to file a bond to answer for damages in case the complaint should be found to be malicious. If, in a criminal case, the judgment of acquittal is based upon reasonable doubt, the court shall so desire. In the absence of any declaration to that effect, it may be inferred from the text of the decision whether or not The acquittal is due to that ground. Article 30, when a separate action is brought to demand civil liability arising from a criminal offense and no criminal proceedings are instituted during the pendency of the civil case, a preponderance of evidence shall likewise be sufficient to prove the act complained of. Article 31, when the civil action is based on an obligation not arising from the act or omission complained of as a felony, such civil action may proceed independently of the criminal proceedings and regardless of the result of the latter. First, I'd like to tackle nga when you are criminally liable, it also follows that you are civilly liable. Article 29 would provide nga even if there be an acquittal on the ground that the guilt of the defendant has not been satisfactorily established, and that is equivalent to one that is reasonable doubt, it does not preclude the complainant or the plaintiff in this case to file a civil suit under Article 29. Because under Article 29, even if there be a dismissal or acquittal of a criminal prosecution on the ground that the guilt of the accused is not proved beyond reasonable doubt, still, a civil action for damages may be instituted. Ay lain-lain og preponderance of evidence ang gi-require. Kay sa criminal case, what is required is guilt beyond reasonable doubt. In civil cases, it's only preponderance of evidence. Okay? The same is true with Article 30 and Article 31, which provides that when the civil action is based on an obligation not arising from the act or omission complained of as a felony, such civil action may proceed independently of the criminal proceedings and regardless of the result of the latter. Remember, Article 31 is different from Articles 29 and 30 because Articles 29 and 30 are not to be independently instituted as opposed to Article 31. Okay? Article 29 and 30 only presupposes nga wala kay gi-institute nga civil action together with the criminal action. Article 31 would provide nga you can actually institute a separate or independent civil action or simultaneously with that of the criminal action. When you say an independent civil action, this is one that is brought distinctly and separately from a criminal case, allowed for considerations of public policy because the proof needed for civil cases is less than that required of criminal cases. But with the injunction in general that success in financially recovering in one case should prevent a recovery of damages in another. It should also be noted that bringing of independent civil action is permissive and not compulsory. Okay? Articles 32, 33, 34, and 2177 give instances of independent civil actions together with Article 31. Diba niingon ta ganiha nga when you are criminally liable, you are also civilly liable. But note that in Article 21, this contemplates a case where the obligation does not arise from a crime, but from some other act like that of a contract or a legal duty. Remember guys nga dili lang ang criminal prosecution or sa criminal prosecution ka makaklaim og civil liability. Okay? Article 1157 of the new Civil Code enumerates the other sources of obligation from which the civil liability may arise as a result of the same act or omission. These are the following. The law may be a source of obligation from which civil liability may arise. Second, contracts. Third, quasi-contracts. And quasi-delicts. Okay? Ang ikalimaan na is crime. So, Article 33, on one hand, also provides that in cases of defamation, fraud, physical injuries, a civil action for damages entirely separate and distinct from the criminal action may be brought by the injured party. Such civil action shall proceed independently of the criminal prosecution and shall require only a preponderance of evidence. Let us discuss Article 31 and 33 together by discussing the case of People versus Bayotas. What happened in People versus Bayotas is this. Rogelio Bayotas was actually charged with rape and he was eventually convicted on June 19, 1991. Pending appeal of his conviction, Bayotas died on February 4, 1992 at the National Bilibid Hospital due to cardiorespiratory arrest secondary to hepatic encephalopathy secondary to hypocarcinoma gastric malingering. Consequently, the Supreme Court, in its resolution on May 20, 1992, dismissed the criminal aspect of the appeal. However, it required the Solicitor General to file a comment with regard to Bayota's civil liability arising from his commission of the offense charge. The issue here is, does death of the accused pending appeal of his conviction extinguish his civil liability? The Supreme Court answered in the following wise. Okay? Ningon ang Supreme Court, death of the accused pending appeal of his conviction extinguishes his criminal liability as well as the civil liability based solely thereon. Meaning, ang na-extinguish ra is the civil liability arising from the crime. If other sources of obligation such as laws, contracts, quasi-delicts, quasi-contracts, wala na-extinguish. Okay? Ngayon ang Supreme Court, as opined by Justice Regalado in this regard, the death of the accused prior to final judgment terminates his criminal liability and only the civil liability directly arising from and based solely on the offense committed. That is, civil liability ex delito in sensu strictior. Corollarily, the claim for civil liability survives notwithstanding the death of the accused, if the same may also be predicated on a source of obligation other than delict. Article 1151 of the Civil Code enumerates these other sources of obligation with which the civil liability may arise as a result of the same act or omission, as follows: law, contracts, quasi-contracts, quasi-delicts. The Supreme Court further said that where the civil liability survives, as explained earlier, an action for recovery therefore may be pursued but only by way of filing a separate civil action subject to the provisions of the rules of criminal procedure. And this separate civil action may be enforced either against the executor or administrator or the estate of the accused depending on the source of obligation upon which the same is based, as explained earlier. Finally, according to the Supreme Court, the private offended party need not fear a forfeiture of his right to file this separate civil action by prescription in cases where during the prosecution of the criminal action and prior to its extinction, the private offended party instituted together therewith the civil action. In such case, the statute of limitations on the civil liability is deemed interrupted during the pendency of the criminal case conformably with provisions of 1155 of the Civil Code. That should thereby avoid any apprehension on a possible privation of right by prescription. And again, the Supreme Court in conclusion said that applying this set of rules to the case at bench, we hold that the death of the appellant Bayotas extinguished his criminal liability and civil liability based solely on the act complained of, which is rape. So, in this case, The one that is only extinguished is the civil liability arising from the criminal action. If it arose out of other sources of obligation, it will not be extinguished. Okay? Articles 34 and 35 are matters of reading. Article 34 provides that when a member of a city or municipal police force refuses or fails to render aid or protection to any person in case of danger to life or property, such peace officer shall be primarily liable for damages, and the city or municipality shall be subsidiarily responsible therefore. The civil action herein recognized shall be independent of any criminal proceedings, and a preponderance of evidence shall suffice to support such action. Article 35, when a person claiming to be injured by a criminal offense charges another with the same, for which no independent civil action is granted in this code or any special law, but the justice of peace finds no reasonable grounds to believe that a crime has been committed, or the prosecuting attorney refuses or fails to institute criminal proceedings, the complaint may bring a civil action for damages against the alleged offender. Such civil action may be supported by a preponderance of evidence, and upon the defendant's motion, the court may require the plaintiff to file a bond to indemnify the defendant in case the complaint should be found to be malicious. If during the pendency of the civil action an information should be presented by the prosecuting attorney, the civil code shall be suspended until the termination of criminal proceedings. Article 36, Prejudicial questions. Prejudicial questions which must be decided before any criminal prosecution may be instituted or may proceed shall be governed by rules of court which the Supreme Court shall promulgate and which shall not be in conflict with the provisions of this code. What is a prejudicial question, ladies and gentlemen? Prejudicial question is one which must be decided first before a criminal action may be instituted or may proceed because a decision therein is vital to the judgment of the criminal case. The prejudicial question must be determinative of the case before the court, and the jurisdiction to try said question must be lodged in another tribunal. Mura na og pagpanguyab. Okay? Prejudicial question ani before kasugton, the prejudicial question is unsa man tinuod ba nga imo kong gihigugma? That should be the question that must be determinative of the answer yes sa pagpanguyab nimo, okay? Well, legally speaking, there are requisites to the prejudicial question. First, the civil case involves facts intimately related to those upon which the criminal prosecution would be based. Just start with this, guys. Naa ni duha ka kaso, civil and criminal, okay? The second requisite is in the resolution of the issue or issues raised in the civil action, the guilt or innocence of the accused would necessarily be determined. And third, jurisdiction to try said question must be lodged in another tribunal. Example is if si Juven would file for a violation of the anti-squatting law against Marie over his alleged property, okay? And then Marie on one hand would interpose the defense that, Juven, you are not the owner of the property. I am the owner of the property. So that defense of Marie would now constitute as a prejudicial question. Remember nga dapat there has to be two cases nga existing, ang criminal o ang civil. So si Marie in this case has to file for another case claiming ownership. Unya kailangan i-establish niya dito that indeed siya ang tag-iya. Kailangan tong humnon tong kasuha because that is the prejudicial question. If ma-establish ni Marie nga siya ang tag-iya, there is no squatting. Okay? If di ma-establish ni Marie, now, the question in the criminal prosecution, if there was indeed squatting, would now be determined. Okay? Sa una, guys, before the effectivity of the family code, the validity or the nullity of the first marriage is a prejudicial question to the criminal case of bigamy. But because of Article 40 of the family code, which provides that the absolute nullity of a previous marriage may be invoked for purposes of remarriage on the basis solely of a final judgment declaring such previous marriage void. This question on validity or nullity of first marriage in bigamy cases would no longer be raised as a defense. Okay? Kaysa una man good, kung ikiha og bigamy ang ban na for marrying twice or asawa as the case may be, the common defense would be, oh, my prior marriage or my previous marriage was not valid. It was null and void. So, kailangan i-establish siya that that first marriage was null and void, because if it can be established that that first marriage is null and void, there's no bigamy in the first place. Mao na sa una ang depensa sa mga magpakasal o kaduha katulo and all that. But today, effective during the passage of the Family Code, gispecify gyud in Article 40, nga ang absolute nullity of a previous marriage may be invoked for purposes of remarriage on the basis solely of a final judgment declaring such previous marriage void. You cannot unilaterally say that my previous marriage was void. There has to be a final judgment declaring such previous marriage void. Okay? Another instance is a criminal prosecution for damage to property. Ang depensa karon sa imong gikiha for damage to property would be this: you are not the owner of the property. So, there is a separate civil action that would establish the ownership of the said property, and it should be resolved first before you can claim damage to the said property. So that, ladies and gentlemen, is prejudicial question. We now move to persons. Title 1, Civil Personality, Chapter 1, General Provisions. Okay? Persons, ladies and gentlemen, is a concept in the law wherein we talk about personality. You have to remember that without personality, you cannot do acts with legal significance, or you cannot be a subject of legal acts or relations. Okay? A person, friends, is any being, whether natural or artificial, capable of possessing legal rights and obligations. Okay? There are two kinds of persons: natural persons and juridical persons. When we say natural persons, these are human beings. When you say juridical persons, these are persons created by operation of law. Now let's start off with Article 37. Article 37 provides that juridical capacity, which is the fitness to be a subject of legal relations, is inherent in every natural person, as is lost only through death. Capacity to act, which is the power to do acts with legal effect, is acquired and may be lost. When you say juridical capacity, this is the fitness to be the subject of legal relations. When we talk about capacity to act, this is the power to do acts with legal effect. A baby, ladies and gentlemen, does he have a personality? Yes, naa siya juridical personality, because a baby is fit to be a subject of legal relations. The question is this: pwede ba siyang mamodel, or he can have TV ads? Yes, pwede. But does this baby have a capacity to act? No, because no matter how many contracts he sign, it produces no legal effects. Kay baby pamansiya. Articles 38 and 39 would say that minority, insanity, or imbecility, the state of being a deaf mute, prodigality, and civil interdiction are mere restrictions on capacity to act and do not exempt the incapacitated person from certain obligations, as when the latter arise from his acts or from property relations such as easements. 39 provides that the following circumstances, among others, modify or limit capacity to act: your age, insanity, imbecility, the state of being a deaf mute, penalty, prodigality, family relations, alienage, absence, insolvency, and trusteeship. The consequences of these circumstances are governed in this code, other codes, the rules of court, or in special laws. Capacity to act is not limited on act of religious belief or political opinion. Now, we go to Article 40. Article 40 provides that birth determines personality, but the conceived child shall be considered born for all purposes that are favorable to it, provided it be born later with the conditions specified in the following article. The following article, Article 41, provides that for civil purposes, the fetus is considered born if it is alive at the time it is completely delivered from the mother's wound. However, if the fetus had an intrauterine life of less than 7 months, it is not deemed born if it dies within 24 hours after its complete delivery from the maternal womb. Remember, ladies and gentlemen, that while birth determines personality, personality begins at the moment of conception. Personality does not begin at birth, it begins at conception. Okay? This personality at conception is called the presumptive personality. It is, of course, essential that birth should occur later, otherwise, the fetus will be considered as never having possessed any legal personality. Example, a woman is pregnant and say the father is Joven. And then Joven would donate the 1 million pesos to the fetus. Is it a valid donation? Under the law, the fetus is given presumptive personality. Okay? However, it must be born in accordance with the law in order for the donation to be effective. If it is not born in accordance with the law, then the donation is not effective. Ang common ani nga question sa bar is this. Let's say si Joven would give to the fetus 1 million pesos and nanganak karon ang babay nga gibuntisan ni Joven, example rin ni Joven. And then pagpanganak, ang bata namatay. Okay? The question is, can the mother inherit? Diha mo sud ang issue. Kung ang mama, because when you are a child, basically wa man kay anak as a child, so ang imuhang compulsory heir is ang imuhang parent. In this case, imuhang mama, baron, okay? The particular case would lend to Articles 40 and 41. Unsa may pasabot ana? As long as the child was delivered completely from the maternal womb and it is alive, the donation is valid and the mother can inherit. However, if the fetus had an intrauterine life of less than 7 months, it is not deemed born if it dies within 24 hours after its complete delivery from the maternal womb. If, let's say, the woman nga gipabuntisan ni Joven nanganak prematurely, let's say on the 6 months and 15 days sa iyahang pregnancy. Nigawas ang bata. But after paggawas sa bata, after 10 hours, namatay ang bata. The donation is not valid, okay? Because under the law, if the fetus had an intrauterine life of less than 7 months, it is deemed born only if it survives within 24 hours. If it dies within 24 hours, after its complete delivery from the maternal womb, it is not deemed born. Okay? But there's no question if natao siya beyond the 7-month intrauterine period. Okay? I hope that is clear. Article 42 provides for the instance wherein civil personality is extinguished. Ningon ang 42, civil personality is extinguished by death. The effect of death upon the rights and obligations of the deceased is determined by law, by contract, or by will. Article 43, ladies and gentlemen, talks about presumptions on survivorship. It provides that if there is a doubt as between two or more persons who are called to succeed each other as to which of them died first, whoever alleges the death of one prior to the other shall prove the same. In the absence of proof, it is presumed that they died at the same time, and there shall be no transmission of rights for one to the other. Remember that Article 43 applies when the case involves two or more persons who are called to succeed each other. In all other cases, we should apply the provisions on the revised rules of court. Okay? Chapter 3 provides for juridical or provisions on juridical persons. Article 44 provides that the following are juridical persons. Diba? We talked about earlier, we have natural and juridical persons. Unsa maning mga juridical persons? These are the following: the state and its political subdivision, other corporations, institutions, and entities for public interest or purpose created by law. Their personality begins as soon as they have been constituted according to law. Corporations, partnerships, and associations for private interest or purpose to which the law grants a juridical personality separate and distinct from that of each shareholder, partner, or member. Kani nga mga provisions, guys, will be discussed further in your subjects, mga corporation law, public corporation. Question: can the sole proprietorship be given a juridical personality? Example: Juan Sari-Sari Store, owned by Juan de la Cruz. Can Juan Sari-Sari Store be given a juridical personality? Dili ha? Because Juan Sari-Sari Store is owned solely by Juan, and the personality of Juan is not separate and distinct from the Sari-Sari Store. Remember lang nga, sole proprietorship does not have a separate and distinct personality from its owner. Okay? Anyway, I'll go back to the article or provision, Article 41 ha. Nakalimot ko nga a fetus is accorded full personality in case of support. Okay? Dili kailangan mataw ang bata before pa siya suportaan, because ang bata while in the maternal womb needs support, or the fetus actually needs support. Ang iyahang pang check up, vitamins, and all that. So dili pwedeng moingon ang amahan o wala pa na personality, di pa na siya pwedeng makaklaim og support. No, because a fetus is now afforded full personality by virtue of the presumptive personality with respect to support. Good day, everyone, and welcome to Persons and Family Relations. We are now on the topic of marriage. Ladies and gentlemen, when we talk about marriage, we talk about the concept of marriage, the requirements when you enter into a contract of marriage. Then after this, we will talk about the consequences of marriage. After the status of marriage, you will see that in the subsequent provisions, it would deal on the consequences of marriage, which would provide for the rights and obligations between husband and wife, the property relations between spouses, the paternity and filiation, family home, parental authority, among others. But also note that these consequences also apply to those not involving marriages. Okay? The consequences of marriage can also be made applicable to cohabitation without the benefit of marriage. So now, we will start with Article 1 of the Family Code of the Philippines. Article 1 provides that marriage is a special contract of permanent union between a man and a woman entered into in accordance with the law for the establishment of conjugal and family life. It is the foundation of the family and an inviolable social institution whose nature, consequences, and incidents are governed by law and not subject to stipulation, except that marriage settlements may fix the property relations during the marriage within the limits provided by this code. The concept of marriage here, ladies and gentlemen, would tell us that a marriage is a special contract. Why is it a special contract? Because naturally, it is not an ordinary contract. An ordinary contract, ladies and gentlemen, is governed by the law on obligations and contracts. Marriage is governed by the family code. In ordinary contract, you provide for the grounds for termination. However, in marriage, this cannot be done. Also, you will find in Article 1 that marriage is a permanent union. Anong ibig sabihin nito? Once you get married, that is forever na. Okay? And it is also stated that it is between a man and a woman. Not a man and a man, not a woman and a woman. This is between a man and a woman. Entered into in accordance with the law. This only means that you have to comply with the requirements provided for by law in order to get married.
You cannot just say, we have to be married in accordance with this one and that. If you do not comply with the requirements provided for in the family code, you are not considered married. Alright? For the establishment of conjugal and family life, conjugal refers to the relationship between the husband and the wife. Family includes the relationship with the children. Kasi in the past, family life lang yung nilagay but minor issues were actually raised later. Sinasabi ng iba, what if the couple cannot have a child? Can they get married? So in order to close this issue, dilagay na nila yung word na conjugal. Okay? It was already included in the family code. A piece of advice, I believe if you familiarize Articles 1, 2, 3, 4, 5, 6 of the family code, I think you will have a better understanding of the subsequent provisions of the family code. So I suggest you better consider familiarizing all these provisions and try to really understand the concepts underlying these provisions. Okay? That's Article 1. We now go to Article 2. Article 2 provides that no marriage shall be valid unless these essential requisites are present. Okay? Before we proceed with that, I'd like to make an emphasis that in order to enter into a contract of marriage, there are actually essential and formal requisites. Article 2 would provide for the essential requisites. Article 3 would provide for the formal requisites. Now back to Article 2. Sabi ng Article 2, no marriage shall be valid unless these essential requisites are present. First, legal capacity of the contracting parties who must be a male and a female. And second, consent freely given in the presence of the solemnizing officer. Let us discuss first the first paragraph of Article 2, legal capacity of the contracting parties who must be a male and a female. When marriage speaks of legal capacity, it talks about specific requirements, ladies and gentlemen. 3 aspects yan Yung first, minimum age requirement. Sabi ng batas, it must be at least 18 years of age. Okay? Second aspect, absence of any relational impediments. Just because 18 years old na si Maria doesn't mean na makakamary na siya. Kasi, what if they're siblings or maybe cousins which are actually prohibited by the law to get married? And the third is, the parties must not be married yet. Also, legal capacity of the contracting parties includes that they must be a male and a female. Klaro yan na male and a female. Ang question lang here is, when is a male considered a male? When is a female considered a female? This is already defined by the Supreme Court in the case of Silverio versus Republic and that of Republic versus Kagandahan. Let's start first discussing the case of Silverio versus Republic. Anong nangyari dito sa Silverio versus Republic? Rommel here was born and registered as a male. Si Rommel admitted that he is a male transsexual and he is anatomically male but feels, acts, and thinks as a female, and that he had always identified himself with girls since childhood. Si Rommel here underwent psychological examination, hormone treatment, breast augmentation, and sex reassignment surgery. And from then on, sabi niya, I have always lived as a female. And in fact, according to him, he was already engaged to be married. So ang ginawa ni Rommel, he sought to have his name in his birth certificate changed from Rommel to Meli, and his sex from male to that of female. Kasi you cannot marry if male to male. So the trial court rendered a decision in favor of Rommel in this case. So the Republic of the Philippines, through the Office of the Solicitor General, filed a petition for certiorari in the Court of Appeals. And the Court of Appeals rendered a decision in favor of the Republic. Kaya itong case na ito napunta sa Supreme Court. And the issue that was raised in the Supreme Court is this: whether or not si Romel is entitled to change his name and sex in his birth certificate. So how did the Supreme Court decide on this case? The Supreme Court said that Article 376 of the Civil Code provides that no person can change his name or surname without judicial authority, which was also amended by Republic Act 9048 on clerical error law, which does not sanction a change of first name on the ground of sex reassignment. Before a person can legally change his given name, he must present proper or reasonable cause or any compelling reason justifying such change. In addition, he must show that he will be prejudiced by the use of his true and official name. In this case, according to the Supreme Court, he failed to show or even allege any prejudice that he might suffer as a result of using his true and official name. Further, according to the Supreme Court, Article 412 of the Civil Code provides that no entry in the civil registrar shall be changed or corrected without a judicial order. The birth certificate of the petitioner contained no error. All entries therein, including those corresponding to his first name and sex, were all correct. Hence, no correction is necessary. Article 413 also of the Civil Code provides that all other matters pertaining to the registration of civil status shall be governed by special laws. However, according to the Supreme Court, there is no such special law in the Philippines governing sex reassignment and its effects. Under the Civil Register Law, a birth certificate is a historical record of the facts as they existed at the time of birth. Kinlaro pa talaga ng Supreme Court na sex of a person is determined at birth. Okay? Visually done by the birth attendant, either the physician or the midwife, by examining the genitals of the infant. Considering that there is no law legally recognizing sex reassignment, the determination of the person's sex made at the time of his or her birth, if not attended by any error, is immutable. And for these reasons, according to the Supreme Court, while petitioner may have succeeded in altering his body and appearance through the intervention of modern surgery, no law authorizes the change of entry as to sex in the civil registry for that reason. Thus, there is no legal basis for his petition for the correction or change of the entries in his birth certificates. The remedies petitioner seeks involve questions of public policy to be addressed solely by the legislature and not by the courts. So in this case, the petition of Romel was denied by the Supreme Court. So that is clear na the sex of a person is determined at birth. Okay? Di mo pwedeng i-change yan because of medical intervention. But this is different. There's actually an exception here. Okay? If it is a case of CAH or the so-called congenital adrenal hyperplasia, okay, or the so-called intersex. This actually happened in Republic versus Kagandahan. What happened here is this. Si Kagandahan alleged that she was born in January 13, 1981, registered as a female in the certificate of live birth, but while growing up, developed secondary male characteristics and eventually diagnosed with congenital adrenal hyperplasia or CAH. Further, she alleges that she had clitoral hypertrophy in her early years at age 6. After an ultrasound, it was also discovered that she had small ovaries, but at 13 years old, tests revealed that her ovarian structures had diminished. It stopped growing and had no breast or menses. And for all intents and purposes, as well as in disposition, considered herself a male. Okay? To prove her claim, si kagandahan presented Dr. Michael Sionson of the Department of Psychiatry of the UPPGH, who issued a medical certificate stating that kagandahan is genitally female but her body secretes male hormones, has 2 organs of which the female part is underdeveloped. So the issue here is whether or not correction of entries in the birth certificate of kagandahan may be allowed in order for her to change her sex or gender from female to male on the ground of her medical condition known as CAH, and that her name from Jennifer to that of Jeff under the rules of court. How did the Supreme Court rule in this case? According to the Supreme Court, kagandahan undisputedly has CAH. CAH is one of the many conditions that involve intersex anatomy. Ultimately, according to the Supreme Court, we are of the view that where the person is biologically or naturally intersex, the determining factor in his gender classification would be what the individual, like kagandahan, having reached the age of majority, with good reason, thinks of his or her sex. Kagandahan here thinks of himself as a male, and considering that his body produces high levels of male hormones, there is preponderant biological support for considering him as being male. Sexual development, according to the Supreme Court in this case of intersex persons, makes the gender classification at birth inconclusive. It is at maturity that the gender of such persons, like the respondent, is fixed. So that is clear already, ladies and gentlemen. When we talk about being a male and a female, it is always determined at birth. Except, of course, when it is a CAH, like that in the case of Republic versus Kagandahan. We now go to paragraph 2. Consent freely given in the presence of the solemnizing officer. Kailangan may consent freely given. What do we mean by freely given? Commonly, when we talk about freely given na consent, it must not be tainted by any vices of consent, diba? Dapat walang fraud, walang insanity, and all that. And also note that the consent must be given in the presence of the solemnizing officer. Now, you have to remember that consent is actually different from the motivation to get married. Okay? Let us now see what the Supreme Court said in the case of Republic versus Albios, explaining the difference between consent and the motivation to get married in the following video.
We'll try to answer the question kung is it only love that is the consideration for marriage. Gugma ra ba gyud ang rason nganong ang duha ka individual mosuod sa kaminyoon. Kaning consent freely given. When can you say that your consent is freely given? Okay? Ang ato ang usual nga nasabtan ani is this: wala ka ilara, wala ka gi-shotgun diha, dili shotgun marriage o ka gihadlok, wala ka nabuang pag-ingon nimo I do and all that. So this is considered now nga ang imuhang consent is freely given. Pero we have to make a distinction na consent is really different from motivation for getting married, because you might enter into a contract of marriage because say 30 naman ko, ganahan ako magminyo and all that, or ganahan lang kong companion, or ganahan ko magkaanak. We have different concepts, mga God. We have different reasons why we want to get married. So we have to distinguish this from consent and motivation. Pareha aning kaso nga ato ang i-discuss karong hapuna, ang Republic versus Albios. What happened here is si Albios gusto siya nga mahimong Amerikana. Maong nakigminyo siya og Amerikano, okay? Pero unahon sa nato ang parties before nato i-discuss ang facts sa case. Ang parties here kay si Filipina, si Albios, and the American citizen, si Fringer, okay? What happened here is this: si Albios entered into a contract of marriage with Fringer, okay? Nangambisyon siya nga mahimong Amerikana. So, they got married with the purpose nga i-process ni Fringer ang iyahang American citizenship nga application. And in fact, tungod anang ilahang sabot, nihatag si Albios og $2,000 ngadto kang Fringer. Karon ang nahitabo, human sa ilang kaminyoon, wa naman nagpakita niya si Fringer. Si Fringer niuli sa US, gidaang $2,000, wa na ni balik diri sa Pilipinas, wa niya gibayran si Albios, so si Albios nahabilin diri og niingon siya, wa na gyud koy mahimo anay di na gyud ko Amerikana, moadto na lang ko sa korte kay akong ipa-declare nga null and void ang among kaminyoon on the ground nga wa gyud toy consent nga freely nga gihatag on my part because we never had the intention to have a conjugal and family life. Kani man siya, void among kaminyoon, wa gyud toy consent freely given on my part because I only gave my consent to the marriage on the condition nga mahimo kong Amerikana. Okay? But it never happened. So, Your Honor, please declare this marriage as null and void. That's the issue here. So, giunsa man ni kaha pag-decide sa Supreme Court. Atong sa taon, guys. So, ang desisyon sa Supreme Court, mao ni, based on the above facts, consent was not lacking between Albios and Fringer. In fact, there was real consent because it was not vitiated nor rendered defective by any vice of consent. Their consent was also conscious and intelligent as they understood the nature and the beneficial and inconvenient consequences of their marriage, as nothing impaired their ability to do so. That their consent was freely given is best evidenced by their conscious purpose of acquiring American citizenship through marriage. Such plainly demonstrates that they willingly and deliberately contracted the marriage. There was a clear intention to enter into a real and valid marriage so as to fully comply with the requirements of an application for citizenship. There was a full and complete understanding of the legal tie that would be created between them, since it was that precise legal tie which was necessary to accomplish their goal. So ningon ng Supreme Court, di ka kaingon Albios nga wa kay consent because in the first place, you consented to the marriage para mahimo kang Amerikana. So ningon ng Supreme Court, consent here was freely given. In fact, the Supreme Court said further nga Albios and Fringer had an undeniable intention to be bound in order to create the very bond necessary to allow the respondent to acquire American citizenship. Only a genuine consent to be married would allow them to further their objective, considering that only a valid marriage can properly support an application for citizenship. There was thus an apparent intention to enter into the actual marriage status and to create a legal tie, albeit for a limited purpose. Genuine consent was therefore clearly present in this case, according to the Supreme Court. Niingon ang Supreme Court, motives for entering into a marriage are varied and complex. The state does not and cannot dictate on the kind of a life that a couple chooses to lead. Any attempt to regulate their lifestyle would go into the realm of their right to privacy and would raise serious constitutional questions. The right to marital privacy allows married couples to structure their marriages in almost any way they see fit, to live together or live apart, to have children or no children, to love one another or not, and so on. Thus, marriages entered into for other purposes, limited or otherwise, such as convenience, companionship, money, status, and title, provided that they comply with all the legal requisites, are equally valid. So niingon ang Supreme Court, bisan pag unsay imong motivation sa imong kaminyoon, bisan pag unsay rason nimo nganong nagminyo ka, it doesn't matter because it would boil down to your right to privacy as married couple, okay? And ang nindot ani nga portion nga giingon sa Supreme Court niyan siya, love, though the ideal consideration in a marriage contract, is not the only valid cause for marriage. Other considerations not precluded by law may validly support a marriage. The Supreme Court, as a conclusion, nangasaba ni Albios, naingon siya, Albios has indeed made a mockery of the sacred institution of marriage. Allowing her marriage with Fringer to be declared void would only further trivialize this inviolable institution. The court cannot declare such a marriage void in the event the parties fail to qualify for immigration benefits after they have availed of its benefits or simply have no further use for it. These unscrupulous individuals cannot be allowed to use the courts as instruments in their fraudulent schemes. Albios already misused a judicial institution to enter into a marriage of convenience. She should not be allowed to again abuse it to get herself out of an inconvenient situation. Ng Supreme Court, Albios, bisan pag wa ka na Amerikana, you cannot say that you did not freely give your consent. And you cannot say na this marriage should be declared null and void. So that's a lesson for us, guys, no?
So that concludes our discussion this evening. I hope you learned something from that one. And if you have questions, please feel free to comment down below or send me a private message at our Teams class or in my FB Messenger. Tomorrow, we will have our graded oral recitation. Please be prepared. Thank you very much. I'm Ping.